since everybody seems to be ready even before 2 minutes, let's start now. My name is Sam Fleischhacker. I'm a professor of philosophy at UIC, and I want to thank Chicago Kent and the Jack Miller Center for co-sponsoring this conference. And I want to thank Mark, Rosen, and Junaid for organizing it with me. We're really delighted you're all here, and delighted that all the panelists have been willing to speak here. It's been an exciting first session, and I look forward to the second one as well. The procedure with the second session will be slightly different, very mildly different. After each speaker, we'll have about 5 to 10 minutes of questions directed to that speaker. And then after the third speaker, we'll have again 5 to 10 minutes. The first 5 to 10 minutes should be directed to that speaker particularly, but then it'll become sort of open season on all the panelists. We do need to end fairly promptly at our ending time, maybe even a few minutes early, 3:40, something like that, because there are some time constraints, but hopefully we'll have time for a good discussion. One part of the procedure that will remain the same is that I will, like as Mark did this morning, introduce each speaker before they come up rather than introducing all the panelists. So we begin this afternoon with Mustafa Baig, who is currently lecturer in Islamic Studies at the University of Manchester, and in fact is going on from there right now to be a research fellow at the University of Exeter. His major research interest is in the function of Islamic jurisprudence in non-Muslim jurisdictions, precisely the subject of this conference, looking at both classical and modern conceptions. He's just completed a PhD thesis on this topic. He teaches courses on the relationship of the Muslim world with the West, women in Islam, Islamic philosophy and Islamic history, and he serves on the steering committee of the International Abrahamic Forum. Mustafa. Oh, and I will, as I told the speakers, as we come to about 5 minutes before their time, I will put my hand up so if they look over in this direction when they think they're running late, they'll see how much time they have left.
Thank you very much, Sam. First of all, I'd like to start by thanking Sam, Mark, and Junaid for inviting me to this auspicious conference. Incredibly interesting, and I can say that in the UK, from those who have heard about this conference, we're also quite excited about what's happening in Chicago over the next 2 days. Okay, I'm going to be talking about my area of research. Sam pointed towards the PhD, what I've just completed. It's a section from that which talks about the jurisdiction of Islam in non-Muslim jurisdictions. And it's mainly from the point of view of classical Islamic jurisprudence that I'll be talking. In 2008, the Archbishop of Canterbury, the senior-most figure of the Church of England in the United Kingdom, he delivered a lecture called Civil and Religious Law in the UK. Now the lecture tried to define basically what is Sharia and what is the role of Islamic law in the UK. More broadly, it was about what is the role of religious law in the UK. But it touched on the Sharia as well, or a significant part of it. And once he had given his speech, it caused a huge controversy. You may have heard of it over here as well. But on the other hand, it provided an opportunity to engage with debates about Sharia law in the UK and in non-Muslim jurisdictions as a whole. Almost all parts of the media and a large section rather of the political class construed his words to suggest that he was calling for elements of Sharia law to be implemented in the UK, or at least have some sort of space within the legal system that allows parallel jurisdictions. Now we know that in the minds of many, mentioning the word Sharia calls up dark images of beheading, amputation of hands, and so on. Unfortunately, for many people who don't have much knowledge about what Sharia is, as soon as the word is mentioned, immediately they think it's a synonym for things like beheading and the amputation of hands. And for good measure, I'll read one headline, probably the most exotic of them all at the time. And this is from the UK Sun newspaper. It says, Williams, that's his name, Rowan Williams, the Archbishop of Canterbury. Williams, victory for terrorism. The Archbishop argues for introduction of Sharia law in Britain. And the first caption reads, they don't live in a Muslim country. Then Sharia law, Sharia in capitals, words that conjure images of stoning, amputations, lashings, and executions. and coming soon to a court near you, according to the Archbishop of Canterbury, Dr. Owen Williams. Of course, he never said any of that, but that's the way some of the newspapers took it. For a very good response to the immediate outcry, you can see Bernard Jackson's article on the topic, an eminent scholar of Jewish law who was formerly at Manchester University, and that's published in a journal as well now. Another motivation of mine for looking at this topic is also to tackle some of the views of what we might call certain extremists on the fringes of Islam. And as I was an undergraduate student at university, some of these voices were heard on campus. So yes, it's a two-way between the extremists and certain parts of the media, which we might also call extremists. Okay, now Islamic jurisprudence tends to address Muslims, or conceives Muslims as living in Muslim lands, under a Muslim jurisdiction. So most of the legal literature concerns Muslims living under Muslim rule. However, there are certain sections, very interesting ones, that look at the situation of a Muslim coming under non-Muslim rule, and that's what I'm going to look at today. And there's a few questions that I'm interested in today. And we'll start with the initial question of whether or not Muslim jurists even permitted Muslims to live under non-Muslim rule. So just to note that the Muslim experience then is quite different to the Jewish one in the sense that Jewish law, the Jews traditionally living, or many parts of their history living in diaspora. The Islamic situation is often the reverse, where they've often lived, or the norm has been to live under Islamic rule, and then you have the kind of the more rare cases of Muslims coming under non-Muslim rule. From the four schools of Sunni Islam, I'll largely be focusing on the Hanafi school, the largest of those four, and that's mainly because of time constraints and also because they usually have the most interesting bits sometimes that I found anyway on this topic. Okay, Abu Hanifa, who is the eponymous founder of the Hanafi school of law, he's reported to have responded to the following question. I'll put it on here just for convenience for you to allow you to follow it. So it says, I asked, what would you think if a Muslim entered Dar al-Harb? Now, I left the word Dar al-Harb there untranslated, literally meaning the abode of war or land of war. And it says under an aman, which is a security covenant, so some kind of peace treaty security covenant, and becomes married to a scriptural woman, a woman from people of the book, a Jew or a Christian, and so on, from among the inhabitants of that territory. Abu Hanifa replies, I should disapprove of his doing so. I asked, but if he married, will such a marriage be valid? He replied, yes. I asked, then why did you disapprove of that? He replies, because I disapprove of his living in it. So the first controversy that we have in Islamic law regarding the situation of Muslims and non-Muslim rules is whether they can actually live under non-Muslim law. Abu Hanifa's student, Muhammad al-Shaybani, who is among two of his most widely cited students, he talks about the situation, same question, says that the duty to migrate to the land of Islam after Muslims had converted, this is talking historically, according to the majority of scholars, was abrogated at the time of the Prophet in Medina. And he cites the narration of the Prophet that there is no migration required after the conquest of Mecca. Basically, the reason to obligate out of Mecca to Medina was because the Muslims were oppressed. And I'll talk about that in a little bit more detail in just a second. The renowned Transaxonian Hanafi jurist, who's called As-Saraksi, he comments on the words of Shaybani. And he states that migration was obligated in the Quranic verse because Muslims were living under oppression in Mecca. And the obligation will continue to the Day of Judgment if such a cause is found, if such a sabab is found. On the other hand, if such a sabab or such a cause is not found, and Muslims can live honorably, then the obligation to migrate is lifted. Hence, the majority of scholars conceive migration as ending with the conquest of Mecca, in accordance to the hadith that there is no migration after the conquest of Mecca. Similarly, another Hanafi jurist and traditionalist, Al-Aini, he comments on the tradition and says that Muslims fled with their religion towards God and His Messenger, fearing enticement away from Islam. Today, Muslims are able to worship their Lord wherever they desire. And this scholar died in 1453, so you can see this in 1453. He's talking about the freedom of Muslims to worship even if they are in non-Muslim countries or non-Muslim lands. As well as this prophetic narration, the Hanafi jurists had looked at this operative cause, the illah, in the obligation to migrate away from non-Muslim lands. Now, although the opinion of Abu Hanifa, we can see there, does not contradict his followers' opinion regarding migration, but if you did want to reconcile any apparent difference, it could be said that Abu Hanifa's opinion considered the question of Muslims residing in non-Muslim lands with the operative cause in place, and later scholars clarified and elaborated his view by mentioning that if Muslims did not find themselves being oppressed or persecuted, then they could remain in non-Muslim territory. One should also bear in mind that Abu Hanifa merely disapproved and did not forbid Muslims living in non-Muslim lands, and other scholars addressed more specifically the implicit concern, if we can call it that, of Abu Hanifa's statement as to whether or not it was possible to carry out their religious duties. And a late Hanafi scholar from India, Al-Muradabadi, he comments on the verse of obligation in his exegesis and sums up the stance of migration succinctly, stating that if a Muslim is residing in a land where he is unable to perform his religious obligations, that's the fara'id, and is aware of a land where he can practice his faith, then it is necessary, wajib, from the point of view of the Sharia, that he performs migration to that land. Now, the important condition of having knowledge of a land where he can practice his faith without difficulty is also added here. Okay, so now we've got past that preliminary discussion of whether Muslims, or what is the status of Muslims living under non-Muslim lands. We look at how the legal literature then addresses them. Now, the subject of Muslim relations with non-Muslims in classical legal literature is mainly discussed under the book of jihad or of seer, expeditions. And this book in fiqh, in jurisprudence, largely covers aspects of warfare, military warfare, of leadership in war, tax, treaties, spoils of war, rebels, apostasy, and so on. Now, perhaps the reason for all of these different subheadings is because much of the early contact Muslims had with non-Muslims was by virtue of warfare. Hence why we saw the name abode of war given to non-Muslim lands. I will talk about later the definition and how we should look at this, translating this word, Darul Harb in a moment. But among these different sections, there's also a subsection that deals with Muslims travelling to non-Muslim lands with a covenant of security. Now, addressing Muslims in foreign lands as merchants was particularly pertinent, as trading was an important feature of Arab society even before the advent of Islam. And Arab trade is well documented in Southeast Asia, in coastal India, and so on, so I won't go into detail with that. But anyway, trade was an important means by which Islam was propagated outside the Arabian Peninsula. It is therefore understandable why the earliest Islamic jurists addressed Muslim traders in non-Muslim lands. So you can see them addressing specifically the Muslim trader. The socio-economic phenomenon required legal rules to deal with the various particulars, even if that entailed devising hypothetical scenarios comparable to the discourse adopted in other specialisms within jurisprudence. Now let's look at a line from a text of classical Islamic jurisprudence. This is from a work by Al-Baluri, very famous in the Hanafi school. This particular book summarizes the views of the entire school in this particular book, and it holds quite a lot of authority. And it states that if a Muslim enters Darul Harb, or abode of war, as a trader, you see the word trader is mentioned specifically there, it is not permitted for him to infringe on their property and life. So what this shows is that a Muslim could in fact enter Darul Harb, abode of war, in a peaceful state. So one cannot then exclusively ascribe the connotation of war or belligerence to Dar al-Harb, which is often what's done. This is why I don't often like to translate it as the abode of war. I prefer just to call it non-Muslim lands, because traditionally Muslim jurists conceived of the world in just basically two divisions. One was the land of Islam and one was non-Islamic land, which was conveniently given the name Dar al-Harb. But it does not necessarily mean that Muslims are perpetually in a physical state of war with this non-Muslim land. Commenting on this particular statement, because these kind of brief mukhtasar words then have large commentaries written about them, two commentators explain that this is because the Muslim is duty-bound to abide by the security covenant, and that any infringement after obtaining this security covenant is a violation of the law, what we call ghadar in Arabic. And a violation of the law is forbidden, haram. Muslim jurists prohibited any kind of deceit in financial transactions or breaking of local law in this abode of war or non-Muslim land. Such rulings dismiss the notion that Islam only permits hostile relations to exist between Muslims and non-Muslims. Upon the obtaining of a security covenant, a peace treaty, or any kind of contract that's signed, Islamic law does not allow a person to break any part of the law, let alone attack the property and persons living there. Al-Maydani, who's another Hanafi scholar, in his gloss on Al-Qaduri's text, what you can see here above, he adds other generic means of entry into Dar al-Harb, over and above trade, without specifying what these might mean. And you can see it's interesting because in his gloss, where the early text just mentions the trader, it says here, if a Muslim enters non-Muslim territory by way of trade or other means, it's not permitted for him to infringe on their property and life. And probably the reason for the gloss is that somebody does not misunderstood the original text to mean that you can only travel for trade purposes. So from a legal historical point of view, this perhaps indicates and acknowledges a diversification in the reasons why Muslims were traveling to non-Muslim lands. So anyway, this obligation to uphold the Aman is not something specific to the Hanafi school, I'll make that clear. And Al-Mawardi, who's a prominent Islamic jurist from the Iberian Peninsula, he, in his work, Bidayat al-Mujtahid, talks about the different opinions of all the schools, and he mentions the same opinion, indicating towards consensus, that a Muslim who enters non-Muslim lands with a safe conduct or is taken captive but then freed and given safe conduct is not permitted to attack them or their property and has to guarantee them water. So, Al-Mawardi is saying this without mentioning any difference of opinion, because he normally does when there is, among the four schools, points towards unanimity among the established schools on this issue. Okay. Given this obligation to abide by the Aman, the security covenant, the jurists then have to address what would happen if a Muslim contravened the law. So if they did contravene the law, then what happens? In terms of what type of law should be applied? Should it be the local law or should it be Islamic law? This involved defining the extent of the abode of Islam's territorial jurisdiction. Now the Hanafi school in particular hold that Muslim jurisdiction cannot extend to non-Muslim territory. If we look at Abu Hanifa again here, he responds to the question of crimes committed in non-Muslim territory and which system of punishment is applicable. So here it says that, someone asked me, Abu Hanifa is asked, if a Muslim who entered non-Muslim territory under an Aman, security covenant, killed one of their men or seized some property or slaves and took it to Dar al-Islam, and thereafter the inhabitants of this non-Muslim territory became Muslims or sought protection and status in a Muslim country, whether they be there, would you return to them any of their property or their blood money, or the blood money? He replies, no. I asked why. He replies, because the Muslims did it in Dar al-Harb, non-Muslim territory, when Muslim jurisdiction was not operative. Behind this lies a larger concept of the inviolability and protection of life and property. Let's present a case in front of you just to make this clear. If a Muslim is in non-Muslim land and he loans money to a non-Muslim there, or is loaned money by the non-Muslim, then what happens in the case of non-payment if one of them files a suit against the other in a Muslim country? So a Muslim lends some money to a non-Muslim, or it's the other way around, and in the case of non-payment they file a case in a Muslim country. What do classical jurists say? They answer that the Islamic sovereign, the hakim or the judge, will not decree anything in this regard. He will not pass any sort of verdict. The same applies if one embezzles the property of the other. Ghasab. The jurists maintain that wilaya or jurisdiction is a requisite for the enforcement of a decree. In this case, the judge did not have jurisdiction at the time the debt took place, as the judge is not able to adjudicate on those who are in non-Muslim territory in Dar al-Harb. Nevertheless, the judge will issue a fatwa, a verdict. Now, fatwa has not been a death sentence, by the way. The judge will issue an Islamic verdict to the Muslim that the property owed or embezzled should be returned. Now, this is not a legally binding decree that will enforce the return of property, but a verdict that states his religious obligation to abide by the security covenant which he signed up for. Ibn Humam, prominent Hanafi jurist, adds that although the state will not enforce the property to be returned, the fatwa will state that it is obligatory, it is wajib, to return it as the matter remains between him and God. So here we see the difference between a legal obligation in terms of a state injunction and a religious and moral obligation to return the property. The Hanafi state that the inviolability and protection of property stems from territory, not from religion. Al-ihraz bid-dar la bid-din. They do nevertheless split the inviolability into two categories. And that is isma al-muqawwima, which is tied to territory, and isma al-mu'athima, which is tied to religion. This is because the inviolability of life and property that Dar al-Islam was able to offer him has been waived upon entering non-Muslim territory. However, the isma al-mu'athima, which is the sin, is not waived as long as the person is a Muslim, meaning that the sin remains for committing the crime and contravening that covenant of security, that contract, that agreement that was made, even though the Islamic punishment does not, the muqawwima. Hence, the Hanafis differentiate between legal obligation that is connected to Dar al-Islam and moral obligation that is connected to Islam. Now, there's also the case of murder here, which is similar, but it's probably take too much time, so I'll leave that for now. Many of the principles that are mentioned here form the basis for spreading rulings across other sections of Islamic jurisprudence, outside of this discussion in what's contained in the Kitab al-Jihad. For example, in financial law, the Hanafi school rules that transactions that are otherwise prohibited in Muslim territories are permitted in non-Muslim territory. In standard Hanafi texts, one can find the ruling based on a prophetic tradition. There is no usury between a Muslim and a non-Muslim in Dar al-Harb. This is because a Muslim sovereign cannot extend its extraterritorial protection to those living outside of Muslim countries. Hence, their property is violable and unprotected. So in Arabic, they use words like mubah, ghair mahfuz, unprotected, permissible, and so on. And you can see the reasoning given here by a commentary on the previous passage, where the legal reasoning is given why the Hanafi school, it doesn't permit interest, it says that it's not interest. That's an important clarification to make. It doesn't permit interest in non-Muslim countries, it doesn't classify it as interest. Saying that our evidence is the Prophet saying blessings and salutations upon him, that there is no usury between a Muslim and a Halbi, meaning a non-Muslim in non-Muslim lands, and this is because their property is unprotected in their land. So by whichever means a Muslim is to obtain it, it is permissible, provided there is no deception in dealings. This is contrary to a Mustafa, that's referring to a dhimmi here, a non-Muslim in Muslim lands, because his property is protected due to the covenant of security that that person has with the Muslim government or the Islamic sovereign. So you can see here, they first begin by giving a tradition, a prophetic tradition, and then they back that up with legal reasoning and legal arguments as is the way in general. Okay, so that was looking at the jurisdiction of Darul Islam in non-Muslim territory. I'm going to look at now, just briefly, won't take too long on this, the independent jurisdiction of Islam in non-Muslim territory. And Muslim jurisdictions, all Muslim jurisprudence, also dedicated some parts of their legal works to this question of what kind of authority, legal authority, do Muslims hold whilst they are living in non-Muslim lands. Again, it's the Hanafi jurists in particular here who state that it is permissible for Muslims to accept judicial positions from a non-Muslim authority, as long as there is consensual agreement of the Muslims living there. And again, even this is according to most jurists. Some jurists even say that if the Muslim community does not agree to their appointment, even then their positions are authoritatively valid in Islam. But most scholars say that the community, the Muslims, have done a consensus that they agree to the appointment of these judges. These judges then will be recognized under Islamic law, and any Islamic rulings they make in determining, for example, the new Islamic bonds, dissolution of marriage, which we were talking about in the past session, Khula Fasq, for example, marriage of orphans, and other areas of Islamic law that are not in conflict with the laws of the land, are religiously binding in the same way rulings made by an officially appointed judge in Muslim countries. So they hold the same authority in terms of their own legal authority in these lands. And I'll present just to kind of finish off this passage from a Hanafi text which talks about, there's a very lengthy discussion on this particular issue, but same time, I'm not going to go through all of the disagreements, but this is a good kind of summary of the recognized position, is that as for those countries where non-Muslims rule, the Muslims are permitted to undertake the performance of the Friday and the Eid prayer. Now just a note on that, the Friday and the Eid prayers are meant to be carried out by the Caliph, the Islamic ruler, or one of his representatives. And according to the Hanafi school, the obligation, if there is no Muslim ruler, then the obligation to perform the Friday prayer is actually lifted. And in place of that, they can pray the regular afternoon prayer, the Zuhr prayer, which Muslims pray. So the obligation is lifted. But you can see here that as for those countries where non-Muslims rule, the Muslims are permitted to undertake the performance of Friday and Eid prayer. It's interesting because there was some controversy among some scholars actually debating whether Friday prayer is even permissible in a non-Muslim land because there is no Muslim authority. And judges will be recognized as official judges with the collective agreement of the Muslims. It is necessary for the Muslims to request a Muslim governor from them, or Muslim judges from them, who would take care of their affairs. And some legal texts, it's interesting, also mention that in such a situation where there is no Islamic ruler, and Muslims are living in non-Muslim lands, then what they should do is appoint the scholars. So generally they say the most learned, the most able scholar in learning and sincerity should be appointed then to lead and take care of the affairs of the Muslims. And for example, in the case of the Friday prayer, the Imam will then act as a substitute. This Muslim scholar will act as a substitute for a Muslim sovereign. So then the Friday prayers can be carried out in that situation. There's quite a lot more on that one. Let's wrap up by concluding now. Okay, all right. So basically what we've seen here is three questions which I've tried to look at briefly. Why is the idea or the question of whether Muslims are permitted to live under non-Muslim rule, and the jurists pretty much agree on the fact that they can travel and live in non-Muslim lands, with the exception of the Maliki school, who is the most strictest on this, although there are some differences among later Maliki scholars who are more lenient regarding this. But once a Muslim enters non-Muslim lands, then there is no disagreement that they must observe and obey the laws of the land. The other question we looked at was the jurisdiction of Islamic law in terms of its territorial status over and in non-Muslim lands. And then finally, it was the independent jurisdictions of Muslims living under non-Muslim lands. So what we have seen then is that Islamic jurisprudence, and even the book of jihad for that matter, is not solely concerned with hostile relation between Muslims and non-Muslims. Instead, we can observe the multifaceted nature of these discussions, in that the jurists discuss not only matters that regulate military warfare, but in the same section of legal literature, matters relating to peaceful abidance in non-Muslim territory are also discussed. As well as entry into non-Muslim lands through warfare, Islamic law clearly envisages peaceful relations in non-Muslim lands. So this then calls for a more panoptic understanding of how the Sharia sees Muslim non-Muslim relations. Now, although legal manuals were predominantly designed to address Muslims living in Darul Islam, classical Islamic jurists codified complex and profound legal rulings pertaining to Muslims in non-Muslim lands too. In particular, we are able to discern the practical concerns of Hanafi jurists in extending the jurisdiction of Islam to non-Muslim lands. While judges in Islamic lands cannot enforce Islamic law for acts committed in non-Muslim lands because of the lack of jurisdiction, Islamic law makes the subtle yet important qualification that a Muslim will not be relieved from the religious sin or his moral obligations in the event of breaking the law, regardless of his territorial whereabouts. So just looking at the question on our poster about whether or not religious law is a threat to American democracy, I would say on the part of Islamic law that it incorporates the accommodative precepts of living peacefully in a non-Muslim state. And it incorporates the importance of having peaceful and pragmatic relationships with people of other faiths. If properly understood then, Islamic law can in fact provide the principles to enable such peaceful relations to be maintained and even flourish for the benefit of Muslims and non-Muslims alike. Thank you very much.
Mustafa, if you'll stay up for a couple of minutes, we'll take a few questions and then we'll move on to the next speaker. So questions specifically for Mustafa on this presentation.
How do you see the changes in modern times? You talked about classical Islamic law. How it is different from contemporary thinking in Islam? Is it really validating it, or it's moving in a different direction?
Okay, the question basically is, how do you see the contemporary discussion on Muslims in non-Muslim lands? Is it changing, or is it validating, is it shifting? Interesting thing is that the PhD the research that I did was actually a comparative study of classical and modern. One of the things that I found was that the classical material is so rich in terms of what it provides, even though it's not a large section. It's relatively a small section if you look at the big volumes of fiqh. It's so rich and it provides so many principles to work with that can be advanced. And this is one of these issues I have with some of the modern discourse, is that some of the modern discourse assumes that there is a need to break with the past in order to achieve something, or to, in order to be able to tackle the modern challenges. However, there's quite a lot in the classical discourse that one can use, quite straightforwardly, to be honest, in how we need to address, how Muslims should address the contemporary situation. One, a new trend that's begun, some people here might know of it, in Islamic law. One Islamic law is this idea of minority fiqh, or minority jurisprudence, called fiqh. This has been started by a small number of scholars, where they are developing a new whole new breadth of material to deal specifically with Muslims living as minorities. It's quite controversial, just basically because it has this name, what does this fiqh of minorities mean? Does that mean there's two different fiqhs, two laws, one for minorities, one for majorities? So a lot of traditional scholars have opposed it, but it is out there, and they've written particular verdicts, fatwa collections, and there's the European Council of Fatwa and Research. I think over Baig was talking about these councils. That's one quite influential council, and that kind of engages directly with the theory of minority fiqh and has developed it. So they are trying to shift the discourse in that sense by saying that we are in need of a new jurisprudence now to tackle Muslims living in contemporary societies as minorities. I mean, there are quite a number of critiques to that as well, which you can read. One of them, a good one, is of the late Ramadan al-Muti, who just died recently in Syria. You may have seen it on the news. And he's got a short critique there. There are a few other scholars as well. In my own reading, I mean, the theory is quite new if you look at it, but whether the theory kind of matches the practical manifestation of minority fiqh in the fatwas, that's something else to be seen really, and I didn't see much of that in there.
Do you have any thoughts on how some of what we were discussing might relate to Muslims using state courts, secular courts, as arms to enforce the decisions of, for lack of a better term, Sharia courts? Structuring Sharia courts in such a way as to have them work within the secular arbitration framework, like the Muslim Arbitration Tribunal, for example. Do you have any kind of, thinking on the implications of that in terms of fit?
Yeah, well, the lecture of the Archbishop of Canterbury in 2008, Rowan Williams, that was precisely pretty much what he was talking about. He said that's inevitable at some stage that we'll have to incorporate these decisions that are made by Islamic scholars at the Islamic courts and consider them as legally binding in non-state secular courts. In terms of Islamic law, what the classical jurists emphasized was that, as you can see here, and they talked about divorce, marriage, and so on, is that Muslims do set up their own kind of their own courts, or not that the word courts is used, but they have Islamic scholars who hold this authority, which go to resolve their matters and their disputes. In fact, in any such matter which does not contradict the law of the land, they allow Islamic scholars to have a large sway over these matters. Now, in terms of whether these should be recognised by state law in England, in the UK, there are moves by these Sharia councils, and also not only by Muslims, by non-Muslims, such as Rowan Williams, who draw attention to this, that such decisions should be recognised. So a marriage, because in the UK Jewish arbitration, FT courts, that's actually recognised by the state. But at the moment, for decisions made by Muslim Islamic Sharia courts, that's not the case, and some people argue that that's unfair, and they want certain changes made. Decisions made by Muslim courts as well are also recognised in the same way that the courts are as well.
I'm asking, I guess to follow up on that, I'm asking more from the internal perspective of Islamic law. For example, in Jewish law, there's entire jurisprudence built around how Jewish law courts can, Jews and Baig can interact with secular courts and the secular legal system. In Jewish law, there's not much of a problem using secular courts as purely an enforcement arm for decisions that have already been made in accordance with Jewish law by Jewish courts. I'm wondering about Islamic law perspective on that.
Yeah, it's interesting because the Muslim experiences tend to be a bit different in that sense, largely living as majorities and probably having small numbers of people living in non-Muslim lands. So generally, it's more talked about within the confines of Islamic scholars and the community themselves. However, we have the passage here as well of if a non-Muslim, well, it's discussed actually in the context of a tyrant. Is it permissible to accept judicial positions from a tyrant? And that begins with the dispute between Ali and Muawiyah whilst Ali was still caliph. The judges who accepted positions of authority from Muawiyah, were they valid or not? The scholars ruled that they were valid. So then they extend that to a non-Muslim ruler as well. So if judicial positions are sanctioned by a non-Muslim ruler, he appoints judges to carry out Islamic arbitration or Islamic court proceedings, under Islamic laws, that is, dealing with Islamic law, then that will be recognized as valid. So they have this where the judges are appointed by non-Muslim government. The decisions made by this judge, not in terms of secular, in terms of Islamic law, will be recognized as valid and authoritative and as binding.
Sinead, we'll take one more question, and then remember, of course, you can bring other questions for any member of the panel at the end of the whole thing. But we'll take one more for Mustafa, and then move on to Professor Novak.
So thanks, Mustafa, for your talk. I guess the question is about, so I'm really receptive to the idea that the fiqh itself contains all these opportunities. I guess my question is more about whether you've given much thought, or I'm sure you have, and how you think about, how these, I mean, you've talked about this tradition of a very continuous, organic whole, in a way, and how these different dislocations might impact on it, right? So, you put a lot of context on a lot of different time periods, for example. And I wonder, like, this sort of goes back to Lena's comment in the first panel about how context figures into it. So, I mean, this would have clear implications as to how we conceive of these questions now. So I wonder if you've given any thought to that, to the sense in which, like, the tradition may not be as continuous and consistent, one might say, as we'd like to think.
Yeah, it's an interesting question. I have given that some thought. So you can see the scholars sometimes, while looking at the dates for each of them, they are from different time periods, but I was actually quite struck by the uniformity of answers on the topic, despite the different time periods on this particular issue on Muslims and non-Muslim land. So, I mean, whilst I was doing this book, I was trying to see if there's a major break or if there's a major shift. But you find that, I mean, if you look at some of even the early classical work, which is quite striking, it's not really anachronistic to kind of discuss that in a very modern context. That's what I found. And you'll find in some of the modernist discourse, maybe there's a certain aversion to the Hanafis with some certain Salafi modernists, maybe that's why as well. But there is a lack of reference to much of the stuff that the Hanafis talked about, which is interesting. Whereas you can say easily that a lot of that material can still be applied in a very wholesome way, even today. Yes, there are some shifts, but not much. Like, for example, you can see the Muslim trade is being talked about, and later scholars add the gloss of other means. So they were definitely addressing, say, the social, economical phenomena at the time, Muslims traveling around, Sufis traveling around, and so on. But in terms of this dislocation, it's interesting to see that's why I think social context is obviously important how it impacts. And I also think it's the madhab tradition as well, which that loyalty to the madhab tradition and developing and working within that can certainly be seen as well. So that linking back to the tradition, maintaining, preserving, and adding more subtleties and to the tradition as they do it, that can be seen within that. So there's a dynamic of responding to social, political phenomenon in different ages, but it's also adhering to the Quranic hadith and the fiqh tradition which they belong to. So a continuous preservation of that also allows for the classical rulings to be manifested time and time again.
Thank you very much. Our second speaker is Professor David Novak. Professor Novak holds the J. Richard and Dorothy Schiff Chair of Jewish Studies at the University of Toronto, where he serves both as a professor of the study of religion and professor of philosophy. He's a member of University College, the Center for Ethics, of the Joint Center, and of the Joint Center for Bioethics at the University of Toronto. He's the author of many, many books, among which are Covenantal Rights, a study in Jewish political theory, which was named the best book in constructive religious thought by the American Academy of Religion in the year 2000. The Jewish Social Contract, an essay in political theology. Talking with Christians, Musings of a Jewish Theologian, and Natural Law in Judaism. Professor Novak.
I'm very grateful for the opportunity to speak at this wonderful conference that was extended to me primarily, but not exclusively, by my friend Professor Sam Fleischinger. It's also a pleasure to be back in Chicago, my native city, where my family has very deep roots. And once again, as especially this conference, which is of such great importance in terms of the world in which we live. When I was a child growing up here in Chicago, I must have been about 12 or 13, I happened to be snooping through some of my mother's papers in her desk. I guess I shouldn't have been doing that, but I was looking around, and for nothing in particular. And lo and behold, I came upon the naturalization papers of her grandfather. Her grandfather, who came to Chicago around 1881 and became a citizen of the United States in the year 1887. My mother was the eldest grandchild of her grandfather, very close to him. He later became a very prominent politician here in Chicago. And the papers were interesting for me as a child, but one of the statements in the papers especially interested me, and that was that he had to renounce any allegiance to the German Kaiser, because he came from East Prussia, which are called Kurland. It's a question whether he really lived under the Kaiser or the Tsar of Russia, but whatever it was. He had to renounce his allegiance to this foreign rule, this foreign domain, in order to become a citizen of the United States. And that was the rule, by the way, until very recently in American law, that American citizens could not enjoy what we call dual citizenship. In my own case, that rule has expired, and I do hold joint citizenship both as an American and Canadian citizen. But in those days, you couldn't do that. So he had to renounce this allegiance to this foreign domain, and of course, obviously, his allegiance to its law. Domains are ruled by law, systems of law. So therefore, he had to renounce it in order to accept upon himself the authority of the American legal system, which is what any citizen has to do, especially a naturalized citizen. It's interesting, though, that he was not required to give up his allegiance to the real law that he was living under, which was Jewish law. And even though my great-grandfather, as far as I know, at least in his American life, which is most of his life, was not a terribly observant Jew, but he did come from an observant Jewish background in Europe, from a community that was very much governed by Jewish law, and this he did not have to renounce. Very interesting, because the social contract, which is the unwritten contract, in this case it's a written contract actually, between people joining a society, is that one accepts the law or rule of that society. Now, why was he not required to give up his allegiance to a foreign system of law? And I think that the reason for that is that this foreign system of law, by the time he was born in 1866, no longer really had any kind of civil or criminal jurisdiction. It was still living under somebody else's civil and criminal jurisdiction. And therefore, the attitude of the United States government was simply that if he was living under some religious law, this concerned religious matters, what Jews would say, ben adam l'makom, matters between himself and God, and therefore this is something that is basically considered to be a matter of private right in our society. In other words, it's not something that the social contract is concerned with. And the reason it's not concerned with this kind of a relationship, which is law-bound and law-ruled, clearly in Judaism and clearly in Islam, and at least in more Catholic forms of Christianity. It's not governed, it is privatized. And it's clearly that it's privatized because the state really has no interest in your religious practices or what religious rules you're living under. They're considered to be something that is basically a private matter. And a private matter, let's always remember that the word privacy comes from the Latin privatio, which means a privation, something that's somehow less than the public reality out there. And it's basically something that the state is not interested in, and most of us think should not be interested in. So that is the situation, and that is how the United States of America could accept my great-grandfather as a citizen in 1887, because he renounced the public law under which he was living. But as for the private the rule or domain that he was living under, that was really none of their business. And it was of no particular consequence. And of course, this is protected by the First Amendment to the Constitution of the United States. The interesting question is, I know perfectly well why my great-grandfather came to the United States. He came to the United States because Jews were at a civil disability where he was living in Kurland, East Prussia, even though technically they had citizenship after Germany was reunited in 1871. And there were economic reasons, a number of them were quite clear. And therefore, I'm sure that when he left East Prussia for the United States, his family gave him a kind of bon voyage. But I often question myself later on, when I began studying Talmudic texts in earnest, did he go to his local rabbi to ask him whether he had permission to immigrate to the United States? Now, if he had gone to his local rabbi could have given him one of two answers. The local rabbi could have said, "Thank God you're getting out of this place. You're going to have a much better life in America. Wonderful," and give him a bracha, give him a blessing. On the other hand, we know that many rabbis in Europe, especially in Central and Eastern Europe, were very wary of their members of their congregations, their communities, going to America. America was considered to be a wide open place. America was considered to be what they call a treifa medina, an unkosher domain, not because of its law, but because it seemed to be that it was a place where people just did whatever they wanted to do religiously. And I remember my paternal grandfather telling me that he remembers coming on a boat to the United States and actually seeing people who took their phylacteries, their tefillin, which traditional Jews wear every morning, and throwing them overboard. We don't need it anymore. We're free. We're free of this religious law we were living under, and this country doesn't care about that, and we're going to live according to this law. So therefore, the rabbi may have given him one, in terms of economic and political advantage, yes, but this was maybe something that would undermine his faith and his observance. However, if the rabbi had been, let us say, more philosophically inclined, he would have probably tried to work out, or should have worked out, nowadays I think we almost have to work out, what is it within the traditional Jewish system, which is a system of law, of halakha, the titles of this conference, which is considered to be based upon divine revelation. In other words, it is the expansion, interpretation, but the bottom line is that this is something which is given by God. And the dogma of Torah min Hashemayim, of the divine law given to the Jewish people, and other peoples also received divine laws according to medieval Jewish theology, is something which is a non-negotiable doctrine. I mean, it can be interpreted in certain different ways, but it is simply non-negotiable. Anybody who denies it is simply out of the pale of the boundaries of traditional Judaism. But what is it in that tradition that enables a Jew, very similar to the question that we dealt with in the previous presentation, what is it that enables a Jew to live in a non-Jewish domain, and especially a non-Jewish domain such as liberal democracy, which seems to be that the best philosophical explanation of what liberal democracies do and ought not to do is the theory of social contract. The theory that basically individual citizens have a contractual relationship with the state. There are certain conditions on both sides, and that is what has been the justification of a liberal democracy. So we clearly understand why the United States would accept my great-grandfather as a citizen, because he was willing to live under its law, its public law, and not under somebody else's public law. But the question becomes, how could this be validated by Judaism? And actually it is validated by Judaism in the following way. It would seem that at least the most optimal view in the Jewish tradition is that Jewish law should govern every aspect of both individual and collective life. One is to turn it every which way, the Torah, because everything is in it. Or as one rabbi referred to it as Torah Shlema Shalanu, our complete and comprehensive Torah, covers everything. And that indeed is the optimal goal. However, Jews have not for a long, long time been able to actually live in a society that was totally governed by Jewish law. Even when they had autonomy, semi-autonomy of the Kehilot, of the communities in the Middle Ages, they were still living under a larger jurisdiction of somebody else. And the tradition understood that, and it understood it by making a formal distinction. A formal distinction that is made is, a distinction is made between law that governs interhuman relations, which are usually of a civil or commercial nature, called mamona, and law which governs the God-human relation, which is called isur. Those things are really what we call ritual or prohibitions. I don't want to say religious, because both laws are considered to be religious. And therefore, it was clearly understood that even the methods of interpretation of civil law as distinct from ritual law were different. Mamona isur li'alpinin, isur mamona li'alpinin. This is what the Talmud states. And it goes back even earlier than that, because that's by the late statement of the Talmud. It goes back to a famous principle uttered by Samuel of Naradia, who was considered to be an important both religious and political leader. Dina the Malkuta Dina, the law of the domain is law. Originally that simply meant that certain laws pertaining to real estate transactions in the general society could be used by Jewish courts, but eventually it became a rubric for the fact that when Jews enter into a society, especially a society where they're going to be free and equal citizens, as a liberal democracy, that they basically cede to the liberal polity, the liberal democratic polity, rights in the area of civil and criminal law. And even in areas where you have arbitration agreements, as we heard in some of the earlier presentations, this is simply something that has to be under the jurisdiction. In other words, the civil court has to basically authorize that, okay, you can work this out in terms of your own religious community. And this goes even back to a further principle that when it came to commercial transactions, that the basic rule, despite all the rules that were made pertaining to commercial transactions in rabbinic texts as earlier than the Mishnah, even the Mishnah, is hakol k'fi minhag medina. Everything is according to what is accepted commercial practice, provided, of course, that practice is considered to be basically fair. I mean, obviously, if it's grossly unfair, that wouldn't be the case. So that therefore, this sort of a situation where we basically separate one's religious life, which is the relation between God and human beings, and one's more secular life, if you will, I'm using these terms loosely, between interhuman relations, seems to work out very well. We're not going to tell you how to pray. We're not going to tell you what you can eat. We're not going to tell you what day you should rest on. But we are going to indicate, certainly, that even if you have basic civil disputes, inevitably you've got to get the permission of the secular court to have religious adjudication. It's very interestingly that actually Maimonides, one of the greatest of Jewish jurists, argues just the opposite. He says in order for Jews to go to a Gentile court, they've got to get permission from the Jewish court first. So this generally kind of works out, and it fits into notions of separation of church and state, and seems to be a reasonable operation. And then sometimes it has some interesting ramifications. For example, commercial transactions. There's a commercial transaction in Halakha which is called Shari'a and Halakha. That is, that before Passover, Jews are not only not supposed to eat bread and related products, but they're also not to own them. Well, that becomes difficult. What if I have a store? What if I have, an expensive liquor cabinet or whatever? Did the Torah come to impoverish me? Is this a question? No. So therefore, a sale is arranged. It's a very complicated, almost fixio juris type of sale is arranged where somehow or other a Gentile owns this during the period of Passover, and after Passover we have a means for kind of regaining it again. But I remember the first time that I actually, because I was a practicing rabbi for 23 years, the first time I actually supervised one of these sales, you got a standard form. I filled out and I noticed at the bottom of the sale talked about this has to be according to halakha, according to Jewish law, and according to the laws of the state. According to the laws of the state. Now, I can't imagine anybody summoning a lawyer to advise them on this kind of a transaction, but somehow or other they recognized that this had to be consistent with accepted commercial practice in this case, American law. But that's a kind of an unusual situation. So therefore we have this notion where actually my great-grandfather, the state could clearly accept him as a citizen, and he, in good faith, if he thought it out, which he didn't, but he thought it out, is clearly the Jewish tradition indicated that this was something that was permissible, not the optimum. The optimum is full rule of Jewish law, but in the world in which we live short of that time, this is something which is considered to be acceptable, if not ultimate. The problem arises when we deal with what we would call domestic or family matters. And I'm going to specifically refer to marriage. Marriage does not fit into this public-private divide the way Sabbath observance or the dietary laws or whatever fit into this public-private domain. Why? Because even though the Jewish system, like Christian system, Muslim system, has detailed procedures for the initiation and the termination of marriage, that is marriage and divorce, nonetheless, the state takes an interest in what Jews are doing vis-a-vis marriage and divorce, because there are civil implications of these relationships and the termination of a relationship. I'll give you an example. When I served as a rabbi, congregations officiating at weddings, I was told by older colleagues, and of course I did it at the time, nobody seemed to object, that before you agree to officiate at this marriage, to be the Masader Kedushin, which means the person who kind of arranges, because the couple really marry themselves. Before you do this, they must have a civil license. I'm going to show you the civil license. And you have to register with the local authorities so that you can sign that document. I always thought that was kind of strange that I was being turned into a clerk, an unpaid clerk, for some municipality. And I take great pride that I never at these occasions said, by the power invested in me by the state of Illinois or whatever, because I didn't, and some people objected, they felt that they weren't married unless they heard those magic words. I didn't do that, because frankly I didn't see that as my function. And I would have much preferred we had the situation like in France. In France, where you go to City Hall, get married, and then if you want some religious ceremony, find some religious group that'll accept you as a member and do it. And on the other hand, which actually had much more teeth in it, when I served on a rabbinical court, which I served for a number of years, we would not even initiate the writing of a bill of divorce yet until the people brought the civil divorce with them. And there are actually cases where rabbis were penalized for issuing religious divorces where there wasn't a civil divorce because there were questions of divisions of property. And also rabbis who officiated in marriages of people who didn't have civil licenses. It happened in one interesting case a number of years ago in Florida, where widows and widowers didn't want to lose their widow and widower benefits according to Social Security, but they wanted to get married and they certainly didn't want to live in sin, and therefore there were rabbis who were actually officiating, and they were actually penalized. I mean, they were actually, in some way or other, they were in prison, but I think they were fined or whatever, told to cease and desist. So the state has an interest in this, and therefore we can't make this neat divide between public and private. Now, when this is the case, then therefore, it seems to me that there are two principles that are involved in terms of Jews being involved in an institution which the state has an interest in, but also is religiously conducted. And that is, there's a maximum and a minimum. The maximum is that I see what the state is advocating as being a direct application of what the Jewish tradition considers to be universally valid law. The Jewish tradition says that there are certain norms, some call them the mitzvah of the name Noah. Noah was the progenitor of all humanity, that apply to all human beings. And they apply to all human beings not because the Jewish tradition tells other people what they should do, but all human beings were living under these laws, or should be living under these laws, before God gave the Torah at Mount Sinai. And in fact, this is a very interesting question of how religious traditions promote universal laws that they claim are not based on their own authority. And I've just completed a book with my University of Toronto colleague, Professor Andre Emon, and Professor Matthew Levering, a Catholic theologian, on how this notion of natural law or universal law works in Jewish, Christian, Islamic traditions. We just finished the manuscript. So maximally, I can see certain interests of the state. I don't know if the state wants to promote family life, they want to promote children being raised properly. This clearly is something which ought to be done. Is considered to be rooted in God's will, but not something that one requires a direct revelation for. It's considered to be something that is kind of rationally evident. And therefore, I can see this as the state, in effect, enhancing the law of God. Minimally, this means that if the state is promoting a practice that according to my tradition is something that human beings ought not to do. In other words, it directly contradicts what the Jewish tradition considers to be universal law. And there's virtual unanimity on what this is more or less between Jews, Christians, and Muslims, the three monotheistic religions of revelation. Then I have a problem. Can I, in good faith, maybe not leave this society, but at least not participate in this institution? And what I mean specifically in terms of the context today, the hot button issue is the question of same-sex marriage. Now, same-sex marriage is the law of the land in Canada, but I can tell you the issue has by no means been settled. It's been adopted by a number of American states. The President of the United States is now in favor of it, but it is a tremendously debated topic. I have, on this question, have had an ongoing public debate with Professor Mustafa at the University of Chicago. Our last engagement was at Stanford University Law School, and you can read our statements in the California Law Review. But in this case, this is clearly something that the Jewish tradition and the Islamic tradition and the Christian tradition. So it's not just a natural law, it's also what's called Jurisprudence. In other words, it seems to have a kind of consensus, at least among religions of revelation, that this is something which ought not to be done. This is something which ought not to be done, that marriage is between a man and a woman. Okay, now we get to debate on what the rationale is and whatever, all of that, but clearly this is what is taught. Now what happens when the society in which I live basically not only permits this, but actually gives it its blessing? Then this becomes a problem. How does one deal with this? Well, very interestingly enough, when same-sex marriage was only a fact in my province of Ontario, Canada, a number of evangelical clergy removed their names from the marriage registry. They simply said that they could no longer participate in this institution, and they told their congregations, we are prepared to officiate at weddings that meet the standards of what we consider to be our law. And some of them said, and if you're going to have a civil ceremony, then we can't do that. Others said, look, we're just not going to get involved in the civil institution. What you do is I'm very similar to the French system. We're not going to worry about what you did. And to be perfectly honest, were I officiating as a rabbi in Ontario, I would have probably done the same thing. Because it's not a question of gay rights, it's a question of what is the institution of marriage? What does it mean? What does it mean not just for Jews, what does it mean universally? And therefore, this is a case where clearly the state is requiring me, if I'm going to be on the marriage registry, to participate in an institution that I consider to be contrary, in a minimal sense, contrary to the law by which I live, and by the law by which I think everybody else ought to be living as well, not because I say so, but because this precedes me and even my tradition. So therefore, how could this be worked out? And I think that it actually could be worked out in the terms of civil unions. I don't think that actually marriage is, first of all, and I've discussed this with some of my colleagues in the faculty of law, why does the state have to be involved in marriage at all? Well, there are reasons for it and whatever, but I mean, I'll give you an example, if it's 40% in Canada of heterosexual couples who are living in long-term relationships are living without benefit of either church or state. And I can't imagine the figures are different in the United States. So therefore, if 40% of heterosexual people are opting out of marriage, and only, if last figures, about 16% of gays and lesbians are involved in civil marriage, then we have a large number of people who simply are not interested in marriage, but they are interested in some kind of structure or order to their relationships. So therefore, if we had civil unions, and they could be of a variety of nature, I mean, we'd have, let's say, a son living with his elderly mother, where there would be certain rights, in terms of inheritance and power of attorney and whatever. They don't have to necessarily involve a sexual relationship at all. This might very well be the situation. So therefore, in conclusion, I would just indicate that my ability to participate in good faith and be indeed proactive in a liberal democracy, whether it's the United States of which I'm a citizen or Canada of which I'm a citizen, depends upon the fact is not the state, at least that civil institution, something which, even if it's not a direct application of what I consider to be universal divine law, but if it is simply contradicts it, whether I can be a participant therein. That is the question that needs to be discussed, and that's a question that I think perplexes those of us who want to avoid the extreme of simply saying that the civil state and its laws and its values govern everything in life, as opposed to those like the Amish, like the Hasidim, who really don't regard themselves as part of civil society at all. It's a very fine line to walk, but I think that there are resources within the Jewish tradition for Jews to be able to deal with this, and I'm convinced, after working with my two colleagues, that there are resources in the Christian Islamic traditions as well. Thank you.
Very much. So questions for Professor Novak. We'll take 2 or 3, and then of course more at the end of the panel.
I think if you would stand up, people could hear your question. And
2 things. If God has made a law, in my case, Muslim, then that law applies to me. If I send you to become a legislator and make laws, in that case, if the man or woman make laws for me, then that will be applied to all of us. So the divine law is very individual to me as a Muslim, as a Jew, to another person as a Catholic or whatever. So the big difference between the divine law and the human-made law, which applies to everyone, which makes it above the divine law. So as long as the human law is not infringed by the one divine law, then we are fine. The way I understand it, and living in this country for 25 years, especially in the state of Hawaii. And so recently what happened when legalization came of the same-sex marriage, then a friend of mine asked me how, as a Muslim, we can deal with it. I said, first, honestly, it's none of my business what they do in their home. But then the imam jumped and he said, no, it is your business what they do in their home. And I really did not want to get into a long debate with the imam and make it my business what 2 persons of another religion they do in their bedroom. And so, and this involves my 2 good friends, 2 women, married happily. And so that is legal in the state of Hawaii. And then a 3rd person asked me, what do you think of it? I said, I really don't know what to say. They look like happy people, and so if the state allows them, good for them. But I really like both of them. And so if I join them, then their marriage is done. I mean, that would be polygamy. If these 2 women married recently, if I join them, their marriage is done, finished. Because that would be polygamy. And I would be sent back to Pakistan, which I really don't want. And back to your grandfather. I think his signing of the naturalization is not very different from mine, which I did in 1995. And in both cases, it says you are not, you are going to forget about that other sovereign that you lived under. And so in my case, I think it was easy for me to get out of the regime of Shari'a and Halakha, good riddance for me in that case. But at the same time, as a Muslim, as if I live in this country, I really don't know exactly the question I was. But the thing to me, I just want to clarify my own head on this thing. If the laws are made by the state by human beings, they can and will infringe on the laws that were made for me in the Quran by God.
Well, I don't know. I mean, the interesting thing, the relation between divine-made law and human-made law is not just a question that everything that I have is divine-made law, and therefore human law is just outside. I mean, certainly the Jewish tradition has a notion, I know the Christian tradition has, and probably the Islamic tradition as well, is there's a certain body of law that clearly is based on revelation, and clearly the interpreters of revelation not only have the right and the duty to interpret, they also have the right to make laws which don't necessarily, are not deduced from divine law, but enhance its overall purposes and clearly don't contradict it. So therefore it's already an internal problem before it's an external problem. But I mean, that becomes, a very important issue there to discuss. But the only way that one can really deal with that question in general society is by some kind, and here I'm, making my own case, so to speak, is some notion of natural law. And clearly we have it in the traditions where clearly there are norms that apply to all human beings. And therefore, when I propose things in general society, I consider them to be consistent with rationally understood purposes, which indeed are the purposes of the divine one. In other words, the divine one has both, the Calvinists have a distinction between general and special revelation. And I think that is an important rubric for enabling, at least in my tradition, for Jews to participate in good faith in civil society, and not only just simply go along with things if it happens to agree with their law, but also to even be proactive. But have to be critically proactive. And that is the notion that there's a universal law that is also divine law, but not deduced from specific revelation. And there are those in the Jewish tradition who denied that. There are those in the Christian tradition who denied that. There are those in the Islamic tradition who denied that. It's an interesting divide in all three traditions. But I think it's the only way that Jews can be participants in both liberal democracy and now what we call multicultural societies.
I saw two hands in the back, and we have some time constraints, so those of you who have other questions, if you save for the end of the panel, that would be great. So Charlotte and then Professor Broad.
Thank you. Thank you, Danny. I wanted to just ask, I'm not clear what you mean by participate or not to participate. How would you choose, let's say the Supreme Court, which they're not really going to do anyhow, but legalize same-sex marriage in this country. So how would you choose to no longer participate? I mean, what does that category mean to yes or not participate in our liberal democracy if that becomes the law for next?
Well, I give the example of participating in the institution of marriage. There are clearly people who, for very non-religious reasons, have decided that they want some kind of ongoing relationship with another human being, and that they do not want this to be subject to the present institution of marriage. And it's irrelevant whether they're straight, whether they're gay, or whatever. Now, the point is that it's not just religious people who seem to have a problem now with the state of civil marriage. There are lots of other people who have the state of civil marriage. So what I'm arguing is that if we would have an institution of civil unions, then this is an entirely different situation. It gives a situation, and it's truly secular. I I mean, because the problem with the institution of marriage for people, especially who don't have religious traditions, is we know that civil marriage is actually modeled on religious marriage. Civil marriage originated in England, and it applied to those people who could not be married according to the rules of the Church of England, but still, somehow or other, wanted something that looked like it, or that seemed like it. So I mean, in that way, plus by being proactive. Let me give you an example of being proactive. If a Christian says, I think that in this society we should do X, Y, Z, or not do A, B, C, because this is what Jesus taught, then people out there are saying, well, I'm sorry, I don't live under Jesus' authority. However, if I were to say that I think this is something that is God's will, and that God had very good reasons for willing that, which are quite evident, then I can promote the reason, even if you don't accept the source. So it's a question of being proactive. It's a question of being proactive. And being proactive in a good faith means that I can actually promote something in civil society, secular society, if you will, that does not require an acceptance of my revelation or my God, because I consider the reasons to be arguable in what we call public reasoning, what Habermas calls public reasoning. So I mean, in that way, this is how one can be proactive. But I can't accept certain things, not only because I think it's contrary to the law of God, but I think that there are very good reasons why the state limited its interest to heterosexual unions that produce children. And I can spell that out. So it's a question of participation. It's also a question of being proactive rather than saying, well, okay, I'll go along with this because whatever.
Produce children?
Professor.
Is that a requirement?
What?
Must produce children? That's a requirement?
I didn't say must produce children. This could be a whole session in itself. I would simply say that I think that the basic interest of the society and the state in the institution of marriage was primarily because marriages usually don't have to or don't always produce children. And we basically regard it, and it's very debatable, I agree with you, we've decided from long experience that a stable relation between father and mother over a long period of time is what is best for their offspring. Now, we can all the nuances and whatever, but I'm simply indicating. So those are the reasons. You can dispute the reasons, but they're not irrational. And therefore, that is something. Now, if the state has decided something else that I consider to be both irrational and contrary to the will of God, then fortunately, the state, nor the civil society requires me to get married, requires me to officiate at marriages, and I can simply opt out.
One more question from Professor Broyd, and then we move to the next speaker. I realize that there's a lot more we could be talking about, but there will be time at the end of the panel for further discussion.
I didn't want to ask about natural law theology. I wanted to ask the question of prudence, which is the pressing of more ideas of revelation and a common God-based argument, I thought might serve the religious community, broadly speaking, less well than doctrines of contract. Meaning, your basic perspective is theological, and I don't mean that in a critical sense. I promise, and not at all. I'm comfortable with it as an internal doctrine, but as a secular conversation, maybe religious communities are better served pressing contractual arguments rather than revelatory arguments through and through. Does that question make any sense?
Sure, it makes sense. And it makes sense in the following. I agree with you. I agree with you that, and just in terms of contract theory, is the problem of contract, and the greatest contract theorist in contemporary political theory was Professor John Rawls, who says we come to the social contract from a veil of ignorance. We give up everything in the past and become this tabula rasa. We start anew and then we negotiate everything that way. This is outrageous. People come from very thick traditions. I'm supposed to leave everything at the door? No. What I have to do is find out from my tradition what enables me to contract with you in good faith. And the fact is that I would be somewhat skeptical about entering into a contract with somebody if I had no idea what law that person was living under, or what moral code that person was living under prior to our coming to the contract. Even if I thought they were a nice person. The fact is, contracts are between strangers. So I want to know where the person's coming from, so that if the person violates the contract, I have something to hold them up to. So that is the point, but it's not necessarily a strictly dogmatic theological argument, but certainly, Rabbi Baig, you would agree that anything to be justified in the Jewish system has to, in one way or another, have to be rooted in God's law, however indirectly.
I wasn't arguing about the church, I'm arguing about the secular tradition.
But clearly it's what enables us to enter in the contract. The relation with the secular state is totally contractual. So look at where you're coming from, is the question.
Thank you, Professor and Rabbi Novak. Our third speaker on this panel is Eboo Patel, who is the founder and president of the Interfaith Youth Corps, a Chicago-based organization building the interfaith movement on college campuses, and the author of Acts of Faith, which won the Louisville Grawemeyer Award in Religion, and of Sacred Ground more recently. He was a member of President Obama's Inaugural Faith Council. He's a regular contributor to the Washington Post, USA Today, Huffington Post, NPR, and CNN, and speaks frequently about interfaith cooperation on college campuses. His organization also inspired the Interfaith Youth Corps at the Chicagoland Jewish High School, which has a number of representatives here. Eboo was recently awarded the Guru Nanak Interfaith Prize, an award given to an individual to enhance awareness of the crucial role of religious dialogue in the pursuit of peace.
Thank you, Sam. So I much to thank the previous two speakers. Thank you, Professor Novak, for first of all, a very interesting discussion, and secondly, making sure that we hit the mid-afternoon lull with everybody wide awake, which task I don't have to take only upon myself. Thank you, Mustafa, for, again, an interesting discussion, and not only about Islamic law, but you carry perhaps my favorite accent in all the world, which is an English accent from the northern parts of the country where I studied for 3.5 years, but I must say that Manchester was the city I felt the most home in England. It is the most Chicago-like, and not just because Chicago and Manchester compete for who produced house music first in the 1980s, although that is not unimportant, I should say. Okay, so when Sam asked me to do this talk, I paused when he said, we would like you to speak. We're doing a conference on Muslim law, Jewish law, and American law. We'd like you to speak, and I paused and I thought to myself, which one of those do I know less about? The fact is I know equally little about all of them, Muslim law, Jewish law, and American law. I do happen to have, however, some thoughts and opinions on what it means to have a diverse democracy. And so, if you will, I'd like to focus my talk not so much on issues of law, or frankly not on law at all, but on what it means to have a civic ethos, if you will, within a diverse democracy. So, here's the central question of my talk. What kind of civic ethos is necessary for a diverse democracy to achieve pluralism? Let me give you my three-part definition of pluralism. It's a situation in which the identities of individuals and groups is basically respected. That means everything from legal respect, freedom of worship, freedom of speech, etc., to a sense of cultural respect that you are able to, reasonably speaking, advance your appreciative understanding of your own community into the broader public square. My kind of basic definition of respect. Part two, that there are relationships between different communities, that we're not kind of all semi-autonomous zones defined by communal identity having to live within the same geographic territory, but there are relationships between Muslims and Jews, Native Americans and Latinos, evangelicals and secularists, and then there's a commitment to the common good. There's this thing called Chicago or Illinois or America or the planet that we all understand as we all, I think, stake in. and that there are certain institutions or principles that are best under their jurisdiction in a civic way, so to speak, and that we have a stake in promoting, strengthening, supporting those. So that's my definition of pluralism. Respect for identity, relationships between diverse communities, and a commitment to the common good. I should say that that is informed by a set of theorists that I don't have a PhD in political philosophy, but I do take an interest in it. So the Rawlsian notion of a social union of social unions, the Mark and Marty notion of a community of communities, Diana Eck's sense that diversity is not an achievement, it's simply a fact. Diversity is the fact of people from different backgrounds living in close quarters. Pluralism is the achievement. Pluralism is diversity that becomes something positive in which people from different backgrounds live positively together. And again, I define that as respect for identity, relationships between different communities, and a commitment to the common good. That's what I'm after, right? And I want to speak largely about the United States, but I want to recognize that we are living in a world in which just about every society has some internal diversity within it. The opening line of Robert Putnam's classic Skype lecture about 10 years ago is, the one thing we can safely say about any society is that it's going to be more diverse tomorrow than it is today, right? And recent news from everywhere, from Kenya to Myanmar to Iraq to Afghanistan, is that this is no easy thing. It is no easy thing to have a diverse society that achieves pluralism. And what I'm going to say right now is deeply informed by the work of the political philosopher Michael Walzer, who I think has my sense is the best single line on this, which is that the challenge of a diverse democracy is to embrace its differences while maintaining a common life. I'm going to repeat that because that thread goes through my entire talk. The challenge of a diverse society is to embrace its differences and maintain a common life. Walzer says in his classic book on toleration something that Professor Novak kind of hints at when he began with his example of his grandfather. It says that nation states do not generally like to acknowledge other loyalties. Right? So in the case of the United States, in the mid to late 19th century, you had to renounce your loyalty to Prussia or to the German Kaiser or whatever it might be. Generally speaking, you don't like to acknowledge other loyalties. Certainly not ones that are legal territorial in nature, but also probably ones that are religious or community in nature. Let me just give an example of that. In India, there are a dozen separatist movements occurring at any given time, and a reasonable number of them are based on religion. And probably the most prominent one was based on the Sikh identity of Khalistan in the 1980s. But there are many, many examples. Elijah Muhammad and the Nation of Islam movement in the 1960s, which was a separatist movement which at points had intimations of a state of their own or hopes of a state of their own. The point is that by and large, nation states do not like to acknowledge loyalties to other identities. So, when they do, it's pretty remarkable. Right? And part of what I want to talk about is what I think is the remarkable achievement of diverse democracies that acknowledge and support loyalties on both sides of the hyphen, so to speak. My comments are going to be largely about the United States. It's the society that I know the best, but I think that these things are largely relevant for Canada, Australia, the United Kingdom, etc. Let me say that I think there's a two-part danger for diverse democracies, right? And I'm going to caricature this for a second. Let's call the first danger the Iraq danger, okay? Which, if we look at if we look at Iraq today, and for a variety of reasons, many of them having to do with the past 10 years of American invasion and short-term, what some might call it, colonization, there's a significant question of whether there is an Iraq, right? Or whether there are a variety of Shia communities, Sunni communities, and a Kurdish region which are effectively at internal war with each other, right? Do Sunnis recognize the Shia-dominated parliament in Iraq? I happened to meet Barzani from the Kurdish region of Iraq about 8 years ago. We both happened to be doing the commencement addresses at Washington and Jefferson College. And Barzani's card, I kid you not, said Prime Minister of Kurdistan. And I looked at him and I said, on my map, there's no such thing as Kurdistan. There is the northern region of Iraq, which is generally acknowledged as largely Kurdish. But he literally presented himself in the United States as the Prime Minister of a separate country. I happen to have a friend at the State Department who's a senior level guy there, and I mentioned that to him, and he said, oh yeah, we deal with that all the time. Okay? This is only to say that the challenge of Iraq is a challenge of what might call it elephantitis of community identity, and a very minimal sense of state identity. Think about Syria, 6, 12, 18, 24 months from now, whenever that monster Assad goes, right? Is Syria going to be one state? Is it going to be 15 states? Is Lebanon one state, or is it 3 states? Or is it 30 states? Is Afghanistan, once the United States fully withdraws, going to be one country, or 5 countries, or 10 countries? All of this has to do with what I kind of crudely call elephantitis of communal identity. That is one significant challenge of a diverse democracy. A second significant challenge, it's caricatured as called as the France challenge, which is you can't wear headscarves in public buildings in France, right? It is the suffocation of communal identity by the secular state. Turkey went through this for many years. Probably France is the most prominent example of this right now. The reason I want to bring these things up is to kind of acknowledge the very simple but profound Walzer line that this business of achieving, of a diverse democracy, achieving stability and some semblance of pluralism is no small thing. There are untold hazards along the way, and not a few of them have to do with violence, conflict, and death. So I want to speak of the United States as a model, right? And not as the perfect model. This isn't, freedom, fries, and patriotism you're hearing from me. It is simply the recognition, to use a simple case in a way that speaks to principle, that Indians and Pakistanis are taught from day one to hate each other. And when they move to Chicago, they move within 12 square blocks of each other, on Devon Avenue. That is no small achievement, right? For a nation to have that kind of civic ethos. And I imagine you can tell a similar story about Manchester, you can certainly tell a similar story about Vancouver or Toronto. To pause and appreciate for a moment that any immigrant society is, in an era of global ethnic and religious tension, is a society in which diaspora groups of people who are fighting elsewhere live cheek by jowl here on our college campuses, in our cities. They work in the same companies, they go to the same public schools, and they don't kill each other. Does that mean that that there's no tension? Of course not. Right? On too many college campuses I go to, there is like a formal there's a formal kind of no talking doctrine between the Muslim group and the Jewish group on campus. My question then is like, who are you feeding in Gaza or keeping safe in Sderot by doing this? But in any case, it's tension, right? It's a very, very good thing that their compatriots have their arms around each other's throats however many thousand miles away, and they're not doing that here. But those issues cause tension here, which I think underscores what it means, the hard work and achievement of building pluralism in a diverse society. So, if there are 2 major points to the rest of this talk, it is this. They are these. Number 1, that I think we make too much of a rights-based discourse when it comes to building pluralism in a diverse democracy. I think we should be turning the volume up on what I would call a contributions-focused discourse, which is basically not how do I create a space for myself as a Muslim or a Jew in American or Canadian or British society. I'm not saying that's not important. I'm just saying the volume is way up on that, right? I am saying that there ought to be more volume on how do I contribute as a Muslim, a Jew, a Sikh, a Hindu, etc., in a diverse democracy. And the higher we turn up the volume on a contributions-focused discourse, I think the more sense, the better chance we have of establishing a civic ethos which builds and strengthens pluralism. It's the second main point of the rest of my talk, which is the genius, I think, of American society, and perhaps the same can be said of Canada, Australia, Britain, elsewhere, is that the way it achieves pluralism, the way it acknowledges loyalties on both sides of the hyphen is by welcoming institutions that express particular identities and serve the public good. So I'm going to give one or two quick examples of this. I'll say more about this later. But there's a reasonable chance that if you were to get hit by a car on Lakeshore Drive, you would wind up being taken to a hospital in Chicago that was at the very least started by a religious community. Northwestern started by Methodists, Loyola started by Catholics, Rush Presbyterian, University of Chicago founded by John D. Rockefeller's Baptist money, right? These are exceptional examples, I think, of institutions where Catholics get to be Catholic, Methodists get to be Methodist, Presbyterians get to be Presbyterian, to articulate their particular identity in a way that serves the public good. My own sense is that those are the anchors, those are the pillars of diverse societies achieving pluralism. And frankly, to be very provocative here, the amount, if I were to do like a rough thumbnail sketch of the amount of times that I hear those things talked about versus the rights of Muslims, you know, whether we can marry and divorce the way that we want, whether we can probate wills the way that we want, in other words, a rights-based discourse, it's 100 to 1. I would say that those other things, the fact that there are 230 Catholic universities and colleges in America, which is almost 1/10 of four-year higher education. There's over 100 Methodist colleges. There's 26 ELCA colleges. A third of American higher education was at the very least founded by religious communities. Right? There are 500 to 600 Catholic hospitals in America. These are institutions that, I will repeat it again, express particular identity. Right? They lift up what it means to be Catholic in a society, but not in a way that serves only the private community, in a way that serves the public good. So I want to offer a case study here, and I'm entering more deeply into the realms of provocation, although those have been well explored. Thank you, Professor Novak, so I think I'm getting into less trouble than I might have otherwise. But I want to tell the story of Mayor Michael Bloomberg in the summer of 2010. Who it was his Muslim summer, shall we say? And the summer began with a controversy. Muslims and their friends gathered outside City Hall, chanting against Michael Bloomberg for Eid as a public school holiday, right? And the argument is that 12% of New York public schools, the students are Muslim. And New York public schools acknowledge Christmas as a public school holiday, of course. They acknowledge Yom Kippur as a public school holiday. In other words, everybody has the day off, which is to say it makes it much easier if you're a Christian or Jewish and observe those holidays. You don't have to request a special day off. You don't have to make up the homework, blah, 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 right? So Muslim groups decided that they deserved a public school holiday. The second great controversy, which occurs at the end of the summer, of course, is the Ground Zero Mosque or the Cordova House controversy. And I take great interest in watching how Bloomberg navigates these. And by the way, I have a good friend who is in Bloomberg's cabinet. Her name is Fatima Shama. She is a quintessential New Yorker, half Brazilian, half Palestinian, raised largely Catholic, becomes more deeply indebted to and part of her Muslim identity in college. So she is kind of keeping me abreast of Bloomberg's, at least City Hall discourse about this. I also get a 20-minute meeting with Bloomberg a couple of months ago and get to talk to him personally about these things, right? So some of this is coming off the New York Times, some of this is coming from intelligence from my friend Fatima, some of this is coming from a few minutes personally with Mayor Bloomberg. Bloomberg's positions on these things are firm. Okay, and the first thing is he's against Eid as a public school holiday, and he tells the New York Times, if we gave every religious community its holy days off, we would never have any school. And people are furious with him. Muslims are furious with him. The city council takes a symbolic vote. I think it's unanimous in favor of Eid as a public school holiday. Right? Bloomberg is not for turning, shall we say, in homage to the recently departed. He's clear. It's like Muslims ought to take the day off if they observe those days, but we're not declaring a public school holiday. At the end of the summer, he is probably the public figure in America who is most prominently in favor of Cordova House. right? And part of my book, Sacred Ground, a significant thread of the book is on that controversy in American public life. So I spent a lot of time with Bloomberg's speeches on this. And the striking thing about this, I want to point out a couple things, is number one, Bloomberg almost never says, well, we have to allow this because the courts are going to approve it, right? Bloomberg says, I want this in Lower Manhattan. He gives what can only be described as lyrical, beautiful, staunchly supporting public speeches, one in front of the Statue of Liberty, the other at Gracie Mansion on the occasion of an iftar that he hosts, right? And he doesn't just talk about Cordova House or the Ground Zero Mosque as a freedom of worship issue. He talks about it as, I quote, contributing to the vitality of the neighborhood. Okay? So I asked Fatima about this, and she said that she told Bloomberg a story which was very powerful for him, that she wanted her 3 Muslim kids to be able to go to Cordova House and participate in art classes and sports programs with Jewish and Christian and secular kids. In other words, Fatima wasn't playing up the Muslim prayer space on the bottom. She was playing up the YMCA or Jewish Community Center or civic institution type dimensions to this. So here's one way to read Bloomberg's decisions that summer. Okay? That Bloomberg is not willing to accommodate a Muslim request that would be a significant civic disruption. But he is willing to accommodate a Muslim request that, in his view, is a significant civic contribution. Okay? So, if you give people the school day off in New York City, hundreds of thousands of parents have to figure out what to do with their kids that day. Right? That is a significant civic disruption, let's say. Right? And Bloomberg is not willing to do that. Now, you can make an argument that this is a freedom of religion issue. You can make an argument that this is, an American kind of cultural diversity issue, that it's part of the American narrative of being an immigrant and diverse society to be able to accommodate these things. Bloomberg draws the line at civic disruption. It says, too disruptive. And yet, he is willing to literally risk a presidential run. I mean, there are not a few letters in City Hall that said, good luck running for president. You are not going to have my support or my cash contributions, right? Literally risks a presidential run to support Cordova House. And saying again, it's not just because Muslims can worship here, right? There's 2 other mosques within a couple of blocks away. It's the idea, in part, that why wouldn't Lower Manhattan be thrilled when a religious community creates an institution that expresses its particular identity and serves the common good? I believe that elephantitis of a rights-based discourse, when communities are basically only saying, well, you need to accommodate my need to have Sharia in America or Canada, etc. Or you need to accommodate my need to have Halakha here. That only that discourse is extremely dangerous in a diverse society because it serves as a centrifugal force, right? And that, at the caricature end of the continuum, is Iraq. If we only care that the broader society creates space for us to operate under our own set of laws and principles, if that is 80% of our frame of mind, what happens to the notion of relationships between different communities? What happens to the notion of a commitment to the common good? The problem of Iraq is that Shias appear to only care about Shias, Sunnis appear to only care about Sunnis, and Kurds appear to only care about Kurds. Now, there are lots of good reasons for this, right? When you have felt preyed upon by another community, and it's only the people and institutions from your community that have protected you, it makes good sense that you would invest in those institutions. But that is not how you build pluralism out of a diverse society. Right? What I am most interested in is the centripetal force of social cohesion, but not at the other end of the caricature spectrum, which is France. And I think the way we achieve that is by communities spending time focusing on the question, how do we emphasize institution building that expresses our particular identities and also serves the public good? So what does this mean for American Muslims right now? I want to say that if my ideas about diverse democracy have largely been influenced by Michael Walzer, my ideas about Muslim identity with anywhere in the world really have been largely been influenced by Dr. Omar Abdallah, who is a white American convert to Islam, did his PhD at the University of Chicago, lives about 30 miles west of here, and I think it's not too much to say that he is probably, broadly speaking, the most respected Muslim scholar in the United States. Professor Hug, would you generally agree with that? So many very significant American Muslim scholars, Ingrid Mattson, Sheikh Hamza Yusuf, would say that in some ways they come from Dr. Omar. Okay, so the person that I'm quoting here is extremely influential across the spectrum in Islam. By the way, I'm an Ismaili, so I do not recognize Dr. Omar as kind of a lawgiver, so to speak, only as an intellectual with significant insights, interpretations, and influence across the Muslim spectrum. So, Dr. Omar, in a pioneering essay called Islam and the Cultural Imperative, uses this metaphor where he says that the waters of Islam are so clear and pure that they gather the bedrock, the color of the rocks they flow over. And so, in China, Islam looks Chinese. In Russia, Islam looks Russian. In Morocco, Islam looks Moroccan. In the United States, it ought to look American. It ought to take from the color of American rocks what is good and beautiful about America, that there is too much in Muslim discourse, a sense of not just a rights-based discourse, what do we get as Muslims, but frankly a culturally predatory discourse, that you enter into society, and at the very least the other people who are Muslim, you say, well, you have to dress like this, you have to look like this, you have to do these various things. And what Dr. Omar says is that this actually is not in accordance with the principles of Islamic law, right? And he uses a couple of really beautiful examples. He uses the example of architecture, and he says if you go to mosques in different parts of the world, they look different because they take on the architectural styles of those parts of the world. He is this especially beautiful example, I think, of Islam in China, where he says, in China, the term that Chinese Muslim scholars used for Islam, and I'm not going to butcher the Chinese here, but he says it doesn't translate as the religion of Islam, because those terms in Chinese come across as awkward, right? It translates as the religion of the pure and real. And he says that this is something we ought to learn from, we Muslims who live as minorities in other societies, that even if your words don't translate perfectly, you ought to be seeking the idiom of the society that you live in. You ought to be contributing to the society that you live in. I want to walk through a set of things that I get from Dr. Umar about both how he views America and how he views Muslims in America. The general principle is that Muslims ought to seek to be, and I am going to butcher the Chinese term here, wenye, right, which is the Chinese term for indigenous. We ought to seek to be indigenous, not alien, not only separate, but indigenous, a part of the society. We ought to constantly be highlighting our existing contributions to that society. So Dr. Omar will talk very frequently about Muslim athletes like Muhammad Ali. He'll talk about Muslim hip-hop artists like Mos Def and Luffy Fiasco. He's like, we ought to be lifting these people up as people who are contributing to American society, and we ought to be emphasizing the dimensions of Islam and building Muslim institutions that do in fact contribute. Right? I never had a personal conversation with Dr. Omar about Eid holiday, Ground Zero Mosque thing, but my strong guess would be he would say Muslims should not have pushed for an Eid holiday, because there are other ways for Muslims to accommodate that prayer need, which is to say, take the day off of school. But we should not push for a dramatic civic disruption. On the other hand, we should be building things a lot more like Cordoba House. We should be putting our resources, especially now that we have critical mass and at least 2 generations of immigrant Muslims in America, beginning a third of many generations, although interrupted, of African American Muslims, we ought to be building a lot more things that look like YMCAs and putting a lot less emphasis into things that look like mosques. In part because we have a ring of those things already. I'm going to tell 2 more stories and then I'm going to be done. Story number 1. Very quick. Story number 1. Mustafa talked about minority fiqh. And one of the places minority fiqh begins is what could be called the Abyssinian example in Islam. This is in the early days of Islam, when the Prophet Muhammad, may the peace and blessings of God be upon him, sends a group of Muslims to Abyssinia because he believes they'll be safer under the Christian emperor there known as the Negus instead of in pagan Mecca, right? And one of the Meccans who is fighting against the Muslims in Mecca goes to Abyssinia and tells the Negus, there's this group of Muslims here, they're living in your territory, they're taking your protection, but they don't believe in Jesus. And the Negus says, well, bring them to my court. The Negus brings them to his court, and he has his bishops arrayed there, and the Negus says to the Muslims, well, what do you believe in? Who are you people? And the Muslims read from the Holy Quran the verses on Mary and the virginity of Mary. Why is that such an important example? Because the first thing because Muslims don't believe in Jesus as the Son of God. But that's not the first thing that they say. The first thing that they do is lift up a Muslim example that would have resonance with the Negus. They don't lie about their belief in Jesus. They simply emphasize a dimension of their tradition with deep resonance with the society that they are in. Final story, 2 sentences, kind of a quick Sufi tale. There's a story of a Sufi leader who wants to bring his community into a Hindu village in the state of Gujarat in India. And so he sends the Maharaja of this territory a glass. And the signal of the glass is, we want to come into, we want to come in to your village. And the Maharaja has his servant pour the whole glass full of milk and sends it back to the Sufi as if to say, we are full here, right? And the Sufi takes a spoonful of sugar and stirs it into the glass and sends it back to the Maharaja as if to say, we will only sweeten what is here. We will only contribute. I think that's where the Muslim emphasis should be in helping America achieve pluralism.
I saw a hand towards the back.
Question for Mr. Patel. First of all, thank you so much both for your excellent presentation and your excellent work that you do. I was very interested in the rights-based discourse versus the contribution-based discourse. I was trying to figure out how in America there would be an issue what rights of any religious group, Muslim, Jew, Christian, be denied. You gave us the one example in New York City, public schools and the Eid holiday, a right that they wanted that they feel they're not getting. I thought that was just a numbers game. I was brought up on the North Shore. In the 60s and 70s, the schools were not closed early for Rosh Hashanah Yom Kippur. It was a numbers game. The numbers got up so the state aid would be lost. To the critical mass, then they had school off. Wouldn't that be the case in New York schools?
So the 2 things very quickly. One is that the reason that Fatima told me that they give Yom Kippur off is because of the number of Jewish teachers and administrators in the school. Okay. So it's not so much your holy day is holier than other holy days. It's just that there's not enough people around to have school. Right.
That's what I meant by the numbers.
Yeah. Right.
Although in truth, I was referring to the students, not the teachers.
Right. So that's why that. But I do want to say that and people can push back if they think I'm wrong about this, but when there is, in a lot of organizations affiliated with religious communities, there is no small amount of volume on rights rights-based issues, right? So CARE, the Council of American Islamic Relations, will talk a lot about, they raise money based on the idea of protecting Muslim civil rights. And I don't think that's a bad thing. I think that's a very good thing, right? And, you know, there are segments of the Catholic community right now which talk about the infringement of their right of freedom to religion because of the Obama contraception laws, right? Let me just be clear. We, ought to be really grateful that in large part such rights are protected, right? That in fact the courts would almost certainly have allowed Cordova House. I am only saying that if religious communities are, if you were to just tally up the number of times we talk about rights versus contributions, I just think that it's lopsided. When in fact there's an awful lot of contributing going on by religious communities, social scientists say that at least 50% of American civil society is driven by religious social capital. To articulate that as a way of expression of religious identity and a way of serving the public good, affirming both sides of the hyphen, if you will, I just think that does a lot more towards pluralism than we give it credit for.
Professor Broad?
I normally don't tell stories, but I want to share with you a story from my time learning in the study hall at Yeshiva University. It's more years ago than I care to acknowledge, close to 30. And at Yeshiva University in Manhattan, like many cities, there's alternate sides of the street parking. So at 5 to 11, 1,000 yeshiva students get up and move their car from one side of the street to another, except on those days where New York City does not require alternate side of the street parking. And it's about 5 to 11, students in the study hall are starting to get up to move their car, and one of the pious elderly rabbis gets up on the dais, bangs the dais, and says, "There's no need to move your car today. Today is Mary Magdalene's birthday." A ripple of laughter slowly starts to spread through the study hall, reflecting on the idiosyncrasies of a study hall in an Orthodox Jewish institution that 100 years ago could never have made such an announcement. But here we are living in America where the idea that one could say something like this is normal. It was entertainingly funny, but a very normalization. What you described as people living in neighborhoods abutting each other and not fighting, one sees all the time in the United States, not just in serious settings, but even in, there's no alternate street of the parking movement today at Yeshiva University because it's Mary Magdalene's birthday. It seems to me that the anecdotal stories deliver the message here in a very profound way.
So, Professor Boyd, thank you. I want to ask, based off of that, you've told a beautiful story. I am usually in the business of telling stories and letting other people ask provocative questions. I'm going to reverse this for a minute. So in this case, a group of Orthodox Jews are benefiting from a holiness that they don't recognize. So here is my provocative question. I know a situation which is multiplied 10 million times over, okay, of a Muslim female friend of mine who, for some years of her life, was rather Orthodox and traditional, who felt like she was fired from a job as a result of religious discrimination, went to the ACLU. The ACLU took up the case. The lawyer who argued it was gay. Okay. She has the same views as Professor Novak on natural law and homosexuality and probably that time around gay marriage issues as well. Here's my question. That man defended her. Is it not a religious obligation to reciprocate? And, okay, so this is my provocative question.
I think that in the United States, reciprocity, which is, in my view, the social contract, is exactly the norm, and that in Europe, 100 years ago, if we had cars, on Mary Magdalene's birthday, we would have moved them specifically to show that we don't observe. So it wasn't required. And nowadays, in the United States, it's sufficient to know that we all celebrate in different ways, in a reciprocal way, our grand society.
And my sense is, child abusers and other nutcases outside of the circle here, right? My sense is that one of the ways that you build pluralism out of a diverse society in which many of the identity groups have historic reasons for suspicion, etc., is when one of those groups defends you, and therefore you begin on an issue outside of the issue that you might have contention on, right? So the view of Bloomberg opposes Eid as a public school holiday and opposes a set of Muslim overtures on Israel in the Middle East, right? And is in the Muslim doghouse for a while. And after Cordoba House, right, we might be the ones writing him checks for president. This is only to say that one of the beautiful things I think about a diverse democracy, I say this provocatively, is that somebody you disagree with on one thing might defend you on another thing, and that might dramatically change your view towards your fellow citizen. And I think that's one of the ways we get along here.
And I'll go further. The Jewish tradition of expansion of rights has never been limited by Jewish law doctrines of who we like and who we don't like. That's why, to the extent that Professor Novak was critical of it, which is not the only one, I would say as follows. The Jewish tradition has relished and grabbed the contractual reciprocal approach in the United States exactly because it seems to promote not only harmony but expansion and growth of rights. I think the anecdotes are fascinating, but the underlying principle is less entertaining but equally important.
Thank you.
So I see many hands. I did want to interject just one thing. I thought of before, but I thought I should add now anyway. Just less than a week ago, I heard Eboo saying to a group of people involved with interfaith work that it's very important that interfaith work not take place, interfaith discussions and projects that not take place just between a certain small segment of the left liberal population. Little did I think that within a week we'd have a good case to illustrate how valuable it is that we can have significant differences on a number of things, political ones especially, and still have these discussions. So I saw Tim, Jonathan, Larry, and I don't know your name, but you'll be next. Tim. And Robert.
I have a question for Mr. Patel. I enjoyed your remarks. I wonder whether or not there's also a cost that you didn't mention in this emphasis on contribution. In the following sense, it seems like for a significant portion of the last century in the Jewish community, there's been a heavy emphasis on creating Jewish institutions that also provide community resources, and that has been, in some sense, part of the success of Jewish assimilation and acceptance in America in terms of the levels of acceptance and embracing even of Jewish tradition and Jewish customs. And within the Jewish community, this sort of outreach and this desire to emphasize contribution rather than particularity or rights or things that would lead to insularity has led to a level of assimilation in some ways, for many people, appears to have watered down a lot of the Jewish cultural tradition in America. So what you have is a highly liberalized version of religion. So I would agree with you 100%. This has been extraordinarily good for America. It's been good for American democracy, it's been good for American liberalism, and it's been good for American pluralism. And I'm not sure that it's not worth all of those benefits, but I do think that when you look at the Jewish community and its cultural resources now, in terms of what Jewish values are, you can send a child to a Jewish day school in America for 12 years of education and ask them what a Jewish value is, and what you get is social justice, peace, all the same things they're learning at the Catholic school down the block. Nobody talks about holiness or ritual purity or other things that used to be considered core Jewish values, because those are not really values that are part of the discourse of contribution. And in some sense, we paid the price in America by liberalizing our religion.
So you have a view on this?
Say again?
You have a view on this. I think that is the case, right? Now, I think building pluralism on a diverse society leaves everybody half full, right? Unless, meaning that there's significant compromises and costs along the way. I just don't think there's anything denying that. And I think that the communities that have made the decision that they don't want to make those compromises or pay that price, so to speak, you are able to do that in America, but only at great effort. So if you want to be the Amish, you can be the Amish. You are legally able to do that. Now, frankly, you still have to sell your jam to people who are not Amish in order to, build your society. If you want to be the Hasidim, you can do that, right? But if you're going to enjoy the benefits of an open and diverse society and maintain community identity, my sense is the best way to do it is to build these publicly facing institutions and have the private narrative within them robust. So, one good example, I think, of the religious dimensions of American civil society is, try to find a decent private preschool on the north side of Chicago that's not religious based. There are Lutheran ones, there are Catholic ones, there are Methodist ones, there are Jewish ones. Trust me, my wife and I have toured them all, right? And one of the things that we wanted two things. We wanted, outside of a decent preschool education, we were happy when the Catholic preschools talked about saints, because it allowed us to talk about Shia imams, right? In other words, if you have a particularist discourse, it creates space for other people to have particularist discourses as well. And that they would accommodate the special issues of our Muslim child. They would recognize that he's not going to eat pork hot dogs on hot dog day. This is all to say that I think you can have a robust community particular discourse that leads to public-facing institutions. I think it takes more effort, and I think that inevitably there's more compromise along the way. And if you don't want to compromise, you can build, your own micro-bubble community in America, right? That's the other beautiful thing. It's just, you have to do the heavy lifting to do that.
At this point, by the way, a question is going to be for any member of the panel. Jonathan.
I want to criticize Mr. Patel and defend Rabbi Novak.
Oh, you got that wrong.
I've been hearing, I've seen you on C-SPAN many times and heard wonderful things over the years from Sam and the Interfaith and Congress Association, people that work in Israel, about your views and contributions, which were very much in evidence and shining this afternoon. I do want to criticize that last utterly absurd and offensive proposition of misapplication of reciprocity. My brother is an attorney for the ACLU and has been for 30 years, so I have some right to speak about it. I went immediately to child abuse, which, like Nazism, is the standard predicate of absurdum. But let's talk about Hamas and advocating the destruction of Israel. ACLU attorney believes that and defends my sister. Doesn't mean my sister has to then go and support him in his views or his identity or anything. That's a totally impossible, useless suggestion. In defense of Rabbi Novak, I want to say something that I said 30 years ago to my teacher, Rabbi Saul Berman, when he was giving a talk in New York, which is that we who are religiously traditional but politically liberal, which I guess doesn't include you, Rabbi Novak.
Quite the contrary.
Right.
The contrary. On some issues, I'm a virtual socialist.
Right.
Sorry to disappoint
you. Book said he was politically, economically, politically socialist, culturally concerned. Anyway, what I challenged my teacher, Rabbi Berlin, was that we should apply, as the last question about holiness suggested, the same intensity of values and try to get the society to reflect, as we do on civil rights and living wage and immigration and domestic abuse. It also comes into question with abortion and gay rights. I think there are arguments that can be made from a traditional point of view for a liberal conclusion about those issues. But there is a certain silence in the community that Sam was talking about doing dialogue that doesn't want to apply our Jewish, Muslim, Christian traditions in the public realm of those issues at all. I think that's wrong.
I agree with you, and I think that the notion, which is found in all three traditions, that there are certain norms that the tradition says it is inherited from a primordial time, if you will, that apply to all human beings. And these norms function in two ways. Number one, they enable the religious community to enter into discourse with members of other communities or no community, whatever community is. And it does not indicate that we have to kind of, as indicated before, give up the ship, so to speak. There's plenty that only applies to our own community that we actually consider to be of greater importance. So I mean, in that way, this is how this becomes worked out. But I'll give you an example. In the case of let's say abortion, I would say that the teaching of the Torah, which means God's will, is that abortion should only be the case when not performing abortion would be a direct threat to the life or health of the mother. Okay, and we can define what that threat means, and they're broad, but clearly this is meant to be a great exception. On the whole, we are not supposed to eliminate unborn human life. Okay. So in that sense, and if I say to somebody said to me, will say to me, well, why do you think that? Well, it's God's will. Well, who are you to ram your religion down my throat? I said, no, I think it's God's will, and I think God had very good reasons for willing that. And I'm sure you could recognize those reasons. Certainly you recognize that there's some sanctity to human life. It's a question where we draw the lines and whatever. But it's certainly not a question of my ramming, my religion down their throat. The second, this universal dimension, which functions as a necessary but not sufficient condition, is that when you have this perspective, it has a great and powerful and to put a brakes on fanaticism, chauvinism, the type of things where, I want my tradition to conquer the world and tell everybody what to do in just a minute. And therefore, as a break on what we consider to be universally immoral conduct, whether it's conducted inside our community or without. So it has that kind of function. But I think that is what enables us to participate without giving up the ship in that way. But once the secular state, and I'm going to get controversial, once the secular state decides that it's in the business of basically teaching morality to the citizens, teaching values to the citizens, and I have a variety of reasons why I don't like the word values in moral theory, then I think that the secular state has overstepped its bounds. And an example would be when the President of the United States enters into a tremendously divisive issue in this country and indicates that his views have evolved, which means he's basically giving from his bully pulpit an endorsement. And I will contrast that with the Prime Minister of Canada, Stephen Harper, who, when the issue of abortion was brought up in Parliament recently, and it's clear what his views are, he basically tried everything not to get it to the floor because he said this is going to be divisive and whatever and accomplish nothing. And even though I'm sure, and it's quite clear that from his perspective, that this is something that there should be major restrictions on. So I mean, that becomes, I think that the key issue is that when the secular state attempts to become, in some way or other, a church, which gives a comprehensive view of the good, in John Rawls's words, then I think the secular state has overstepped its bounds, and the only limitation on that extension of state power are well-grounded, traditional communities, all of which are religiously based, which want to participate in secular society, but don't want to be overtaken by it.
Okay, we're running a little bit short on time at this point. I've seen 5 hands. What I suggest we do, if people first of all could keep their questions relatively pared down, and secondly, let's take them in a bunch. Maybe let's take all 5, and then the panel will respond and we'll close. So Larry, you're up first.
Well, since I yelled out of turn earlier, as the rabbi of the gay synagogue in Chicago, I'm compelled to speak. And actually, I agree with Professor Novak that it would be better if it was civil unions across the board for everybody, which itself is an invented term by a few legislators in Vermont who were trying to come up with some other category rather than marriage. But the principle, and the principle that I think that the secular state stands for in the United States, is the equal protection of law. And as long as privileges are extended to those who enjoy the benefits of what the state defines as marriage, to those people who enjoy that status, then there's something out of sync. So that's the principle that I would argue has to be extended. It's probably not possible to redefine it all as civil marriage. I also feel uncomfortable signing state marriage licenses. But I think the principle is the equal protection of the law.
I'm Jerry Unger, and I'm a physician with 2 law degrees. I'm also a former medical examiner in the Bronx. I was at 9/11 at the job 25 minutes after the first plane hit. And I watched the bodies get pulled out, and I pulled them out. I still have a 45-foot box trailer of body parts in Staten Island. 2 bombs just went off on Boylston Street at the end of the Boston Marathon. Why are you sitting here talking about plurality? I've also got friends that are Muslim. The idea is that we have no patriotism anymore. I'm also an old Marine and a Vietnam vet. We have, yes, we drove out from 9/11, 2 weeks afterwards, out to Chicago to my daughter's wedding. The number of American flags decreased as we got further to the Midwest. Now I'm looking at people coming, the kids coming back from Iraq. I'm going to Afghanistan to set up a PTO for a healthcare organization.
I'm sorry, sir. I really do have to ask that these be short. I have like 3 other people here, and we are short on time.
What I'm trying to get at is that I also lectured at the War College to turn around and say that the mosque should be at that site. I want to know if you were there after 9/11 and saw the people protesting off the side of the camera. Because then you'd understand why the police department and the fire department, and many of us that work through that, are objecting to that. So the idea of plurality sounds great academically, but you're not dealing with the real world. You're not dealing with individuals. You're dealing with a concept.
Janae.
I don't want to pile on to you here, and this is not in the spirit of criticism, the spirit actually, because I'm actually quite sympathetic to what you're saying, but in the spirit of sort of pushing along the narrative here. I mean, maybe the problem is, or maybe the problem I see with what you're saying is that you're opposing a rights-based discourse to a contribution-based discourse, when in fact they're kind of related in a very specific way, which is that people feel like they want to contribute when they feel ownership over the place they're contributing to, when they feel involved, and a lot of that has to do with feeling that their rights are respected. So they're actually, quite related.
Muhammad?
Can I ask questions to all 3?
You can ask questions to all 3.
I think for Professor Novak, actually, and Mustafa too, I think you both told very captured stories about I guess from the law's perspective, basically the idea of overlapping consensus due to this divisive contract and the idea of obeying the law of the land. But certainly it's got to be the case that there are some kinds of demands that a non-religious state might impose on a believer that requires the believer to say no. Not necessarily to take up arms, right? But to say, no, I will not do this, and I'm ethically obligated to resist in the sense of not comply with these commands because they're substantively immoral. And so I'd like to hear a little bit more about that. Besides just the thing of non-participation. But, Rawls has the example of abortion. If you're a Catholic, you just don't exercise your right to abort, right? That's simple. But what about when the state purports to impose an affirmative obligation upon you to do something? What does Islamic law, what does Jewish law say about that? Particularly if it's something grave like participating in war. Let's say this for both of you. Then for Eboo, I think I'm going to follow up a little bit on Junaid, but first I really like it. I really, really like it. But I think that one way to misunderstand it is to think that these 2 things are oppositional, right? And so I want to press you on this idea that I think could be heard from you, that Muslim Muslims are a little too aggressive in a certain right, when in fact, maybe because I'm warriors, I'm biased toward rights. I think, if anything, it's the opposite. That lots of times Muslims are scared to assert their rights. And so, for example, during the 2010 Ground Zero Mosque Congress, there were a lot of Muslims from Patel who really wanted to just go away, who did not want Muslim community in that time. And I lived there. Actually, I was at 9/11 when the plane hit. I was at North Tower. I lived there for 4.5 years after it. We never moved. And I know how important it is for the Muslim community there to have them. And I insisted to lots of my friends, many of which were opposed to it, precisely because they thought it was too in the face of America. So listen, there's a big Muslim community. I mean, they deserve to have something like this. It's also valuable. I know that the city wants to promote redevelopment. This is a part of redevelopment. And so I see the opposite problem, that Muslims are really unwilling generally to stand up for their rights. And part of democratic citizenship is a willingness to stand up for your rights. If you don't use your rights, you use them, as I said.
We will take one more question, then the panel will respond, then we will stretch briefly for about 2 to 3 minutes, and we'll have our keynote immediately following.
I'm Steve Heyman from Chicago Camp. This is a question for Professor Novak. I like the framework that you set up, where if it's a question of my own religious observance, I look to the religious tradition, but if it's a public matter, I need to look to natural law. But when you engage in this natural law inquiry, it's a different kind of inquiry. I'm not doing it as a Jew or a Christian or a Muslim, but I'm doing it as a human being using reason, trying to find out what the natural law is. And if the state ends up disagreeing with me, it doesn't seem to me it's an injury to me as a member of one of those political religious communities. If you insist, or if I insist that the natural law must be understood in accordance with my own religious tradition, I think really I am imposing my religious tradition, even though I'm purporting simply to be looking to natural law. And I guess the last point has to do with President Obama. If he's a member of the polity and in fact one of our leaders, then he ought to be addressing the question of what universal law or justice requires. And I can't imagine telling the state that it should not be reaching an issue on those issues of natural law, which you said were matters of public reason that we all should be reasoning together about. So I can't imagine what the objection would be to him participating in this debate and expressing his view about it.
So I hope the panelists have recorded the questions and can remember them, because I can't. But let's go from right to left. We'll start with Mustafa and continue to Eboo.
Just a question that Mohammed Fellow addressed to both I and Professor Novak. There are issues where Islamic law will come into clash with the local law, with the non-Muslim law. In that situation, or Muslim scholars generally advise is that where they can abstain and reject or not participate, the way Professor Novak has said, that should be the best option is non-participation. However, if it comes where you are compelled to do things and they are against the fundamental tenets of your faith, or those things that are from the obligations of your religion, for example, a very basic example, if you are stopped from praying 5 times a day, for example, or certain other things, that's what the scholars say, that it's an obligation for you to migrate to a land where you can participate and practice freely your religion. So it's at different levels, I think. If it's at a level where you can abstain and not participate in the way that other people in that society might do as well, so you can argue if such a community is allowed to abstain from such a thing, then why can't I have those same rights within my religion? There's this discussion in England about abortion, where Christian doctors were refusing to carry out abortion. So Muslim scholars that kind of latched onto that and used the case of not only abortion, but other areas as well where they are uncomfortable or their religion does not allow them, that they should be given them same rights as well. But if it infringes on their obligations of their religion, then the Islamic scholars say there's no choice but to migrate from that land, not to create anarchy or fighting or anything like that.
Yeah, in terms of Professor Patel's question about are there certain things that the state would mandate that you could simply say, no, I won't do that because my religious tradition forbids me from doing that. Yes, there are certain areas of killing, for example, that I could clearly indicate that for example, let's take an example of warfare. I mean, even in the Torah, it mentions that exemptions from military service, the person, and the term person is hayarei v'hara levav, the person whose fears and is soft of heart, which usually is interpreted this as some kind of coward, But quite the contrary, one of the rabbinic interpretations is, no, this is somebody who basically says, I cannot kill. I simply cannot kill. And you provide for conscientious objection. So there's within the tradition a certain type of conscience objection. Now you can understand, for example, I'll give an example. In Israel, you have two types of problems with people in terms of killing. You have one type, or any kind of military action. You have people generally on the left who will refuse to, let's say, a situation where you have to go in and displace Palestinians or even engage in killing. And then there are people on the right, the religious right, who won't displace settlers who were in places that Israel has ceded the land. Now clearly you can't run an army that way, but certainly there should be a provision of conscientious objection. I mean, if you can't go along with these policies, then you should be allowed to desist from them. Interestingly enough, in terms of the rabbinic tradition, even if you have absented yourself from war, you still have to participate in some kind of community service, repairing the roads or this sort of thing, especially what kind of war. I mean, there are all kinds of technicalities there. But yes, there are certain situations where this is the case. I would think that for some reason it was ordered or whatever, that a Orthodox or religiously observant Jewish doctor would refuse to perform an abortion where it's not indicated by the question of the mother's life or health. As for the question of invoking natural law, and after you're invoking it the way your tradition has it, are you invoking it the way your tradition has taught it or the way your tradition has explained it? Let me give you an example. My undergraduate education was at the University of Chicago. I was educated by basically Aristotelian philosophers. And Aristotle, in his distinction, in his difference with his teacher Plato, it's not the universal is here and the particular is here. The universal is found within the particular. There's some areas that are just particular, but there's some areas where the universal is found in the particular. So we're dealing with universal norms, yeah, but they have to be taught somewhere. So they're taught in somebody's tradition. However, when we have differences of natural law interpretation between traditions, then it's interesting what you invoke. Let me give you an example. Last Friday, week ago Friday, I was involved in a program with dealt with abortion at the Catholic Center at New York University. And I wanted to make the following argument. I said that when Jews and Catholics talk about a universal prohibition of abortion, we're arguing on natural law grounds. I mean, even though we can provide verses one way or the other, but we're basically saying that this is something that is a rationally evident prohibition. I said, on rational grounds, I consider the Jewish exemption to be more rational than the notion that abortion is never indicated in any case whatsoever, that a woman basically has to carry her killer, if you will. So there was an interesting, and interesting that then we started discussing the fact that actually, by what's known as the principle of double effect in Catholic moral reasoning, let's say that a woman has an ovarian tumor.
Professor Novak, I really have to ask you to sum it up quickly.
Okay, sum it up is that basically they will also, based on double effect, take care of the ovarian tumor, even though inevitably it will lead to a spontaneous abortion. So here's where you can have a dialogue in a very rational context, and include secularists as well.
Eboo. If I had to, I want to close with three very, very brief things. One, if I were to ask Mustafa a question, it would be, what's a Muslim country? right? That term is used frequently throughout your presentation. Is Morocco a Muslim country? Is Indonesia a Muslim country? Is Pakistan a Muslim country? Is it a country in which there's a majority of Muslims? Is there a country in which a certain form of Muslim law prevails? If so, what if it's a brutal form of Muslim law as in the Taliban? So that's a very interesting question. If I were to ask Professor Novak a question, it would be about which natural law, which is to say, a Hindu view of natural law would probably include no killing of animals, which there is some sense of there would be there's a rationale behind that, right? So natural law makes sense to me, especially because it's rooted in the U.S. Constitution, and so it seems to me that you can't accept, now this is kind of a conservative argument, you can't accept the fruits of that without at least some recognition of the roots of that. You're endowed by the Creator, etc., etc., etc. Therefore, it cannot be only a particularist religious argument. There has to be some universal dimension, but it seems to me that there are multiple universals. Again, there's a Hindu version of natural law which would say you don't kill animals. I don't think that a rights versus contribution based discourse is oppositional at all. I did not mean to make that argument, except in the sense that time is a zero-sum game, and we all decide what we choose to talk about. And the point that I am making is that I find myself in circles in which rights are talked about more readily than contributions, which is interesting to me because religious communities have done so much contributing in America, and it feels to me that that is one of the pillars of American social cohesion, which bridges to my last line, which is my response to you. I think the term reciprocity is too strong of a term. I'm going to give a 3-second example of what I mean. I met a Bosnian Muslim kid who was rage in his throat about what Christians did to Sarajevo under Milosevic. He comes to Indiana as a refugee. Who is he resettled by? Christians. Right? And that fact, what's that?
Very different Christians.
Well, but Christians just the same, right? That fact, he comes in with this history of deep hatred for a particular religious community. When he finds that people who pray in a similar way here are defending him, his view of that community changes. I'm simply saying that I think is part of the warp and woof of American society, that groups that we, for reasons of history or parental bigotry or whatever, might have very dim views of. We find ourselves in a society where those groups are sometimes, or individuals from those groups, are sometimes defenders of our dignity and our rights, and that changes our views of those groups. And I think that is a very good thing. The complication is, what happens if you have a dim view of the practices of those groups? If you have a gay civil rights attorney protecting you against in a religious discrimination case. I just want to be clear. I have no dim view of gay people at all. In fact, my sense from my religious tradition, which might not be based on law, it's based on spirit, is that they are equal to me in every way. I am simply acknowledging that other people have different views for their own religious reasons. I think the warp and woof of American society builds towards social cohesion on this in powerful ways.
Let's thank the panel.